Any mention? Okay, of course.
Item number 1.
Lord, this is the PIL regarding, my lord, the 30 progress of this national highway, this Nardan section.
Yes. So what has happened now? What is it?
There have been very subsequent developments. I was just reading the paper today. That in Guwahati, that Maharaja Prithu, the longest has been inaugurated, that completed in 2 years. We are 5 years now here, my lord.
Hmm.
And there have been subsequent developments. The government was given the liberty, my lord, to take action. I think now they have obtained some stay or something.
Hmm.
Led by learned friend appraisal.
Yes.
But in fact, here we were respondents.
You put it off instead. Now it's on. There's a light just below that.
Now it's on.
Ah.
Now it's put it off again.
Now
Yes.
I know.
Yes, yes.
But what has happened was, Lord, there was a direction by your lordships, Lord, indicating, Lord, that the time frame is 31st of July 2026. And Lord, the further extension would not be in a normal course.
Hmm.
Lord, our contention was, my Lord, there were certain issues, Lord, for which there was hindrance and all, my Lord, which they could clear on 17/10. And Lord, a new alignment of the bridge was given on that very day. And on the same date, my Lord, they have issued a notice for cure period, my Lord. Now, my Lord, your lordships, in your lordship's order, my Lord, if your lordship kindly have a look at order dated 26/12 at page 25, my Lord, of my IA, my Lord, if your lordship kindly take up IA
There's
67.
an IA. What is this IA for?
Lord, we had filed this IA, my Lord. We're praying before your lordships for restraining the respondents from terminating our contract, my Lord, because they had issued a notice to terminate.
Page 26.
Yes.
Starting
25.
start from 27. Order dated 24/12.
Yes, yes. My Lord, we'll see para 12, my Lord.
Hmm.
My Lord, Roman 8 last one. Further, no extension beyond 31/7, my Lord, because we have given an extension of time till 31/7, my Lord. That is also without imposing any liquidated damages. No extension beyond 37 shall be granted as a matter of course.
Hmm.
And my Lord, we also file our affidavit in terms of that. We say that, my Lord, some of our payments have also not been made.
Mr. Dubey, you
My
are a
Lord.
contractor.
Yes, yes, my Lord.
Are you still working?
Yes, my Lord.
Are you saying that some termination has been done also?
My Lord.
You have been terminated.
No, my Lord, not. My Lord, in fact, we had, since we did not get any remedy, my Lord, we have a remedy because we have invoked 26(2) of the contract agreement where it provides for conciliation and 26(3) for arbitration, my Lord.
Hmm.
My Lord, certain disputes which we had raised, my Lords, they were not keen to appoint an arbitrator, my Lord. And thereafter, my Lord, we have invoked, my Lord, Section 9 of the Arbitration Act, my Lord, praying before the district judge, my Lord, for restraining them from termination. But we have been granted an interim protection till 23rd of this month, my Lord.
Okay. 23.
But our contention before your lordships is this, my Lords. Till 31/7, we have an extension, my Lord. But let us proceed to work till that time, my Lord, and subject to our performance, my Lord, they may consider our, my Lord. Otherwise, my Lord, if new contractors come in, again, my Lord, the entire thing gets delayed. My Lord, we had also raised issues as regard, my Lord, payment that has been withheld, my Lord, around 7 odd crores, my Lords.
What is that? Running bill?
Yes, yes, my
Is
Lord.
it a running bill?
Yes, yes, my Lord. Well, they have also given some justification why they say part of it is, my Lord, on EOT count and part of it for because we have failed milestone. My Lord, when at least 3 crores I am entitled to, even half of it.
So basically you are against this notice in this IA.
Yes, yes, my Lord.
You are seeking a stay of this notice.
My Lord.
What does the notice say?
My Lord, they have given us a so cause, my Lord, why it should not be terminated, my Lord. And why our bank guarantee and all should not be invoked. And additional costs damages should not be imposed. At page 15, the last page of that notice, your lordship would see para 13.
This is given to you by the
By the executive chief engineer, my lord,
highway.
who is the executing authority, my lord.
Para 13.
Yes, yes.
You are given the 15 days time to make a
Yes, yes.
representation. Have you submitted?
Yes,
anything?
yes, we have submitted our response. my
Hmm.
lord. My lord, we
15
have-
days slaps on which
On
date?
27th, my lord. In fact, 28th was a non-working day, my
So
lord.
that was in February already.
Yes, yes,
So
February.
as of now, what is the situation?
The situation is we have submitted our response, my lord.
Hmm.
Since they had an intention.
They have
But
not taken a
what-
decision till now.
my lord, in fact, before terminating, they have invoked our bank guarantee, my lord.
Where is that?
But that's not there on record. After filing of this application, my lord, we came to know. And that's why we have to move for arbiter section 9, my lord. Well, at this stage, my lord, I pray before your lordship, my lord, that they respond to my applications, my lord.
Hmm. Yes.
Notice-
My lords,
Yes.
this PIL, my lord has seen
Hmm.
many orders were passed.
Hmm.
Initially, this honorable court itself directed to expedite the work of, by the
Hmm.
contractor. They, at one point of time, they gave the excuse that they are having some financial crunch. Now, after some time, they said that they have now managed the financial crunch. They will expedite the work. Nothing was done.
Mr. Ratan, I mean, those things are known to
Yes,
the court.
yes,
So what you need to address the court is that what you have done in the reply.
yes, my lord. I'm coming to
Come to
that.
that, directly.
In the last order on 22nd of 11th of February, there was a specific query by this honorable court to the council as well as the contract representative of the firm contractor. 22nd, that whether till the deadline of 31st July, you will be able to complete the work. They made a statement before this honorable court in para 5 of the order dated 11/2/2026.
Annexure C of this I, my lord.
Yes, they say it's practically impossible.
Yes.
Hmm.
They said that it is practically impossible.
Hmm.
Now, therefore, why should we wait for the contractor till this deadline? When the milestones which they have to achieve every month, they are not achieving it. Why should we wait till when they themselves have stated before this honorable court that it has become practically impossible? Why not we be allowed to take action against them and to terminate them and appoint a new contractor? Why delay? That is the question. Now, they have filed this IA, which is for stay of the notice. They have this is not a PIL by them. It is against them. How can they take these excuses that we have not been paid the running bills and all? We have explained all why we have deducted the running bills and all. They have failed to do achieve the milestones in the required intervals. Now it has become impossible. At this stage, they want to buy time. Even if they are granted time till 31st of July, it has become impossible. They themselves know that they will not be able to complete it. Now they don't want another contractor also to be appointed and do the work. That is the whole thing.
How much,
They themselves, they cannot complete the work.
how
They
much
don't want.
how much of the work is still left?
It is more than 50% of the work is still left.
Almost 50%. Lord.
50%.
Yes.
And timeline, the original timeline was
Lord, original time,
7th of
Lord,
December 2024.
7 December 2020.
24. Extension was given for another 18 months.
and what is your excuse?
Lord, so far as we are concerned, Lord, under the conditions, Lord, we were made to understand that, Lord, in terms of the contract, Lord,
Hmm.
there is an obligation on the part of the authorities to give us 90% hindrance-free land.
Hmm.
Lord, there it should continue up to 5 kilometers of stretch minimum.
Hmm.
Lord, if there is even a small hindrance in 5 kilometers, that would not be construed as 90%. Then I am entitled for extension. Therefore, your Lordship has said it can't be a matter of course. Therefore, when they have extended, Lord, my Lord, timeline without any liability, because they are also in default. Lord, on 17/10, Lord, a revised plan of the flyover has been given to us. And Lord, in terms of Moth circular, Lord, even if it's more than 100 meters, a timeline of 3 years is given for that. Lord, when on 17/10 they hand over me the revised plan, Lord, how I could make a statement to the effect on 31/7, Lord, I could complete it, I could not. But highway part, we have given an undertaking and we are also given a timeline, Lord, that highway part will complete up to the extension time. But so far as flyover part is concerned, Lord, we have given a timeline of 31st March 2027. But we say before your Lordships, Lords, even at this stage, if some third party is engaged, Lord, that considerable time will be consumed. Lord, and that in terms of contractual obligations, Lord, I am also entitled for extension of time.
Okay, today, IA is filed, so will you have a response to this? We'll fix a date. Give your response and give your an additional
My lord-
affidavit. What is the say?
IA is
So,
not.
my lord, this matter needs to be heard because in this manner, my learned friend appearing on behalf of the contractor is submitting is very unfortunate actually. 10% or whatever new plan has been given for the highway, for the flyover, we all know, we reside here. But the fact remains, there are supposed to be 149 pillars earlier. In 3 years, my lord, it is now almost 6 years, they have completed around how much? 80, 90? Is this some sort of, my lord, ultimate sufferer is the public, my lord. He may be very well defend the contractor, I understand, my lord, he is the lawyer, but this is not the manner in which this has to be done. That affidavit, my lord, we filed this PIL because nothing was being done, my lord. When I filed this PIL, my lord, there were only 3 pillars. There were supposed to be 149 pillars. By that time, only around 6 months was left for completion. When I filed this PIL, my lord, no affidavit was filed to that effect saying that this and that was not given. The initial affidavits, your lordship will see the reasons was that first it was rainy season. When the working season came, no money. If your lordship goes to each and every order, that is the manner in which the contractor is working, my lord. And my lord, on 22/9, they gave a categorical, my lord, assertion before this court that the earlier money was not there, but now we have arranged the money. It is reflected, my lord. They should be held up for contempt, my lord. That is how they are doing it. My lord sees it, my lord, every day, my lord comes from UPA. What is going on? There is not a single labor in a single pillar. Where is the superstructure? Raising these technical points and all this all very well. But that is not the fact. We all know that. This is unfortunate. And there are various aspects also, my lord, if I may point out.
Yeah, just a minute. Next week, on the way, I will be there like Tuesday and Tuesday.
Firstly, my lord, the principal contractor is not at all involved.
Okay.
Somehow,
Subcontracted.
yes. Somehow he has managed for it to appear that he is involved. But he is not.
Mr. Pangin,
Yes.
I think we need to hear this matter. So as
But
on-
ultimately, my lord, our
as of-
working season is over next month. This month, my lord.
As on today, since one IA is filed.
Yes.
You respond to this IA and we'll fix
My
it.
lord, In
on
fact,
which,
what my submission will be, that this IA is not at all maintainable. This IA, what they are praying, not to terminate.
so
Which,
that's what, you respond to that and you just inform the court what steps have been taken. We are not passing any interim order.
yes,
There's no work going on. We know that. We have seen it. There's no work going on. Tell us what you have done. And that will be heard on a date fixed. As of today,
On the basis of the assurance given by the Abhishek Kumar on 22/9, my lord, is liable for contempt, my lord.
all right, please write. Heard Mr. R. Duval, London Council, for the respondent number 7, applicant, who submits that by filing this application, the applicant seeks for a direction to the PW authorities not to proceed further not to terminate the contract given to the respondent number 7 in terms of the notice dated 13/2/2026. Stop. The applicant has further prayed for a direction to allow the applicant time till 31/7/2026 to achieve the work program in terms of the extension given. Next para, issue notice returnable by 1 week,
Yes, ma'am.
yes, Malad.
17th of March.
Would it be on 16th, my lord?
Hmm?
16th.
16th.
I know 17th, I have some.
All right, 16th of March.
16th.
No, 16th, actually, normally I believe you have a DB on Tuesdays and Thursdays. Although you may have it any day, but preferably on 17th.
Can it be on 17th, 16th? You know. 16th, better.
17th, maybe.
17 would be better.
17th.
My lord.
You try to adjust. Returnable by 17th. Mr. N. Ratan, London additional AG, appears for the state and accepts notice. Mr. D. Pangin, London Council, appears for the opposite party oblique petitioner and also accepts notice. Extra copies of the application be furnished to them. The opposite party shall make the response on or before the next returnable date for consideration of this, so that the court can take a decision in the matter. List accordingly.
Obliged, ma'am.
17th.
17th.
Item number 2,
Malad, in item 2, this is regarding conferment of ST status to the Yobin tribes. Earlier, there were efforts even by the state government to confer them the ST status.
Which tribe is that?
Yobin tribe in
Lord, I'm
Vijayanagar
appearing
area.
online, my lord. In party, in person, my lord.
Okay. And why is it listed today?
Malad, what?
You have to file an affidavit in opposition.
Yes, Malad. In fact, this matter is going to be placed shortly before the cabinet. Because we have also tried for conferment to the Yobin tribes, but ultimately it is not the state government or the courts who can confer it. It's the parliament. So we'll be placing shortly this matter before the cabinet. My
Cabinet,
instruction. Yeah.
okay.
My lord,
Now,
may
how many tribes are there?
One tribe, Yobin tribe.
Now, how many tribes are there in Arunachal which have been declared as the scheduled tribe?
Their scheduled tribe,
Why is the Yogin tribe left out?
Yobin tribe, they initially their name Yobin tribe did not figure in the presidential order, Malad,
I see.
of 1950.
And when was this discovered?
Discovered in 1972. They were
72.
yes
61, my lord. 1961.
61 because the Assam Rifles they discovered them.
Then why now this approach now in 2025 only?
In between, there were some exercise. Even the state government by a notification
Okay.
conferred them the ST status,
Uh-huh.
but that was not as per the law.
No, it's not for
because-
the state who can do that.
Yes, so that was again cancelled in 2013. Again, 2018 also, there was an effort
What is contemplated by the cabinet then?
contemplated to pass, to place it before the assembly and then
Take the matter up before the parliament.
My lord, this is
You-
a,
you-
my
Mm.
lord, may I submit, my lord, something, my lord? This is a
Yes.
very, my lord, this is a public interest litigations, my lord. It's not
Mm.
adversary, my lord. And we
Mm.
appreciate, my lord, and we bow down to the government where they're going to place before the cabinet. That's fine, my lord. But if you
Mhm.
see the presidential order of 1950 and the local commissions also, my lord,
Mm.
all the tribes, the indigenous, the qualifying words, the indigenous, my lord. All the indigenous tribes are supposed to get the ST certificate or the ST status, the scheduled tribe status, my lord, as per the presidential order. When we see the local commission's report and also the presidential order of 1950, my lord, for Arunachal, for NEFA, then, my lord, it says all tribes, my lord, and all tribes would mean because for at that relevant point of time, my lord, like the Yobin tribes, my lord, we were discovered only in the year 1961, my lord, and
Mm.
at the place where the Yobins live, my lord, we are a very few microscopic tribe, my lord. And the place
Mm.
where we live, till 2 years back, there was no road communication. The people had to walk 7 days, my lord, to reach their villages, my lord. So
Where is
such
the
kind
place?
it's a Vijayanagar Changlang district, my lord. It's bordering to Myanmar, my lord.
On the, in the northeastern side,
Northeast, yes, but the
Yes,
east, we
northeast.
call it the eastern of the east,
eastern
my lord.
side,
Eastern side,
eastern
my lord.
side.
Yes, my
Mm.
lord. So, my lord, now in order to give the benefit of such tribe, because there would be so many major tribes, okay, fine. They have come during the British time, they have been recognized, they have been come in contact, my
Mm.
lord. But some tribes would be remaining like one of the Yobins, my lord, who were never in the limelight, my lord. And the limelight came to very late, 1961, my lord. 1961, then Indo-Myanmar demarcation was done in 1974, my lord. And these people are the indigenous tribe, my lord, who have roamed the jungles of Vijayanagar area, my lord. They were enemies, my lord. They were food gatherers, my lord. So what is happening now? Why this PIL has to be filed? Because, my lord, there was a NCST direction, my lord, National ORGI, the Ministry of Tribal Affairs, all in unison said that the Yobins are the indigenous tribe of Arunachal. Therefore, you cannot deny them the benefits equivalent enjoyed by other indigenous tribe, my lord. Then subsequently, what did the government did? The government did was they extend under the presidential order itself. But why I come before my lord today is because its specific name is not there. Therefore, this is creating a lot of confusions. So, for example, I say few example like there's one student who had got an admission in a film television institute in Pune. His international scholarship was not given to him. Why? Because your name does not figure in the presidential list. And there is another student, my lord. Yobins are very minor, and then education, my lord. Now only they are coming up. And out of that 70 years of their existence, my lord, one student, one candidate passed the Arunachal Civil Service prelims. Prelims. Now, on the last date of the exam, on the last date of just before appearing the main exam, they said that no, your name is not that you appeared in general. I am an indigenous of Arunachal Pradesh. How could I appear in a general, my lord? So there's a lot of confusions is happening, my lord. There's a reason why we have come. Presidential order is
Okay.
very clear. All tribes, very clear.
Where
my
is
lord.
that page number?
My lord, I'll just
26.
show.
26,
26.
26.
where others are there, but you're not there.
26,
Yes, my
yes.
lord.
It says all tribes.
All tribes
All
in the state, including.
Including, my lord.
Yes.
Those are recognized tribes,
These
so
are-
they have been included.
Yes.
And otherwise, all tribes, including those.
Yes, including
This is a
those.
presidential order.
Yes, my lord. So,
This is a presidential order.
Yes.
Where's the beginning? Scheduled tribes order,
Yes.
342, sub clause 1 of the article. Mm,
But how much time will take, Mr. Ratan, how much time government is?
My latest instructions are that it will be shortly placed before the cabinet for,
You should do it as soon as possible because
Yes.
otherwise they will be deprived unnecessarily.
Yes.
So he has already cited 2 instances.
yes. In fact, we also want a permanent solution for them.
Yes. Either way, whatever.
My lord, this is what we have come compelled to constrained to come also, my lord, because being an indigenous tribe, my lord, 70 years we have been deprived, my lord. How many more years we need to be deprived? And only, my lord, the entire tribe, my lord, trust in the judiciary alone now, my lord, because the promises have been made for the past 50 years. Nothing has moved forward.
Okay, this page 26 contains only 16.
Only 16.
There are others also.
Yes, my lord.
Others, my lord, will, from amongst these 16s, separate nomenclatures have been chalked out.
Where is
Okay.
that?
Page 29 is, it's the amendment of the scheduled tribe order, my lord.
29.
Yes, and then in page 30, for entry B, earlier,
Where is that?
in entry B of
Page
page
29.
30, yes, serial number 6, it was Khamti, now it has become Kamti, Thai Kamti.
Mm.
Then for entry 8, that is Mismi, Idu and Taron initially.
Mm.
That has been now Idu, Mismi, Kaman, under bracket Miju Mismi, then Idu Mismi, Taron, Digaru Mismi.
Mm.
That has been. They chalked out within the tribes only.
Mm.
Then in entry 9, earlier it was Momba, now it has become Monpa, Memba, Sartang, Sajalong, and under bracket Miji.
Mm.
Then in entry 10, it was initially only any Naga tribes, but now they have identified it Nokte, Thangsa, Tutsa, and Wancho.
Mm. Still, this is also not complete.
Not complete. So those identified by constitutional amendment, at least there,
So this is one such amendment. Is there any other amendment apart from this?
apart from that, earlier there were.
I don't think it's limited to 16 tribes. There are many other tribes.
It's not limited.
Earlier, yes,
That's why it says all tribes in the state, including.
yes,
So
Malot.
it's it encompasses a very wide thing,
Yes,
field.
yes. Earlier, if Mylord will see at page 26, if Mylord will see the serial number 4, Dafla, that has been now changed into Nishi.
By which order?
This was in the earlier amendment, Mylord.
Earlier it
of
was Dafla.
Dafla, then in 2000 or 2001. And then Galong has become also Galo.
Galo.
Yes.
So anyway, the process is like this only, isn't it?
Yes.
So
The
to the
process
Ministry
is
of Law
that-
and Justice, constitutional amendment has been
Yes.
made. Now, what is the role of the state?
Constitution role of the state is that the assembly will pass a resolution and forward it to the
So
parliament.
why is not the same being passed till now?
In fact, their case, there was a communication with the Ministry of Tribal Affairs in case of Yobin. What they suggested initially, there will be no requirement of constitutional amendment because the sentence which it says all tribes in the state, including it is open-ended. So you by a notification you can. So state government they issued a notification.
Where is that? Is it here?
I believe it is.
Page 35.
Yes.
There, my lord.
State government initially.
That's one way of seeing it.
Yes, but that was again until and unless it is there is a constitutional amendment, constitutional order amendment that cannot be done. That's why this. Even directions were given to the DC to issue ST certificates, but since because it is not there.
But then again, people will always refer to the list. Now,
Yes.
where's the list? In the list, they'll find out you're not there.
Not there. That's
Ultimately,
why
the person.
that's the
individual-
problem they are being facing. That's why to solve this problem,
Mm.
we have taken a decision, the government is taking it, that will place it before the cabinet and then place it before the assemblies. And if it is passed, then forward it to the parliament for necessary
How much
amendment.
time do you require
My lord,
to get the instructions regarding the,
my latest instruction is that we'll be shortly placing this before the cabinet.
shortly means what?
Shortly.
1 week, 2 weeks, 1 month? half a year?
Within, let me be, this, within a month, this will be placed. before the-
My lord, if in the meantime, my lord, before I press for one interim relief, my lord, may I just take my lord to page 46 for a moment? My lord, just take 2 moments, my lord. Page 46. The National Scheduled Caste or Scheduled Tribe Tribunal's observations, my lord. I will take to para 7, my lord. Para 7, that is in page 46. May I just read, my lord?
Yes.
Further, the commission was informed that initially when Arunachal Pradesh was part of Assam and known as NEFA, the list of scheduled tribe with effect from NEFA was specified as all tribes of Northeastern Frontier Agency, including NEFA was upgraded as a union territory in the year 1972 and renamed as Arunachal Pradesh. The Constitution Scheduled Tribes Union Territories Order 1951 was amended, and the same list of scheduled tribes Arunachal Pradesh was specified as all tribes of the Union Territory, including. This list was not revised with a comprehensive revisions order of 1976. The Arunachal Pradesh Union Territory got statehood in the year 1987. It is reported that people belonging to Yobin tribe were getting ST certificate as per the interpretation of the words all tribes of the Union Territory, including. The communities currently specified in relation to the state of Arunachal Pradesh are stated below. So and so, my lord. Then after para 9, my lord. Given the circumstances and the views of the state government of Arunachal Pradesh, that the Yobin community is being disadvantaged by lack of mention of the Yobin community and denial of community certificates, the commission is of the view that the original intention in the presidential order needs to be understood and follows scrupulously. If there is any doubt whether a particular community is an indigenous tribe of the state, then the proposal needs to be formulated along with an ethnographic study. In all other cases, local inquiries with ethnographic study where necessary should suffice for the state to issue community certificates. If the state government continues to have doubts in respect of these indigenous communities, they may obtain clarification from the Ministry of Tribal Affairs. No amendment of presidential order is accordingly required given its provision, which are also not in conflict with the judgment of the Supreme Court. So, my lord, thereafter, what my learned additional advocate general said that the Home Ministry, the Tribal Affairs Ministry says that you don't need an amendment, just give them the certificate. Now that there is no denial that the state of Arunachal is not denying that the indigeneity of the tribe. That is the reason why they have given us the caste, the caste certificates, my lord. Now the problem here is, my lord, some of the officers, as has fallen from my lords, that because for want of a specific name, the students and the job seekers are getting denied. That is precisely the problem, my lord. So, my lord, amendment will come, amendment will take time, my lord. In the meantime, my lord, if these certificates that already been issued, my lord, if this is honored in the as a temporary relief, a lot of students are suffering right as of now, my lord. Now the new certificates that apply to the additional deputy commissioner, what is the additional deputy commissioner of Miao is saying is that since you have filed a PIL, so we are waiting for the outcome of the PIL. It's very unfortunate for him to say that when all these clear standing orders are there, my lord, to say that just because somebody else has gone to the court, therefore I cannot issue you, where there's nothing as such bar, my lord. So if temporarily some reliefs have been given by my lords, will be most grateful, my lord, because this will elevate the problems that is being presently faced, my lord. And in fact, my lord,
Yes. Yes, what?
in fact, my lord, there's a order. I'm just wanted to show there's there was already a communication from the
Okay, just a minute. Just recorded submission and give them some time. Okay, we'll give
My
them some time.
my lord. my lord,
Well, see, we understand your anxiety
my lord.
to have an interim order to the effect that whatever certificate has been issued to you should be honored and all that.
Yes,
But
yes, my lord.
we don't want to complicate things. State is in your favor.
My
At
lord,
this
my lord,
stage, let there be a proper reply and a decision from this court.
my lord, my lord.
So, in the interim, we don't intend to pass any interim order at this stage. All right, Mr.
My
Ratan,
lord,
you get your instructions and you
Yes, yes.
impress upon the authorities
Yes,
that
yes.
this is of
In
utmost
fact,
importance because, like we have understood, this is a PIL. It's not an adversarial litigation.
In fact,
Those who are entitled to get the benefit out of this being belonging to this class should be not denied of this
Yes.
benefit.
in fact,
So
we
time
want
is
a
the factor.
permanent solution for them.
There has to be a permanent solution.
Solution.
So time is the essence now.
Yes.
my lord,
So keeping that in mind, we'll grant you some time.
Yes.
my lord.
Okay. Your good name, Mr.
P. Yobin, my lord.
Mr. P. Yobin, Learned Counsel, appears in person through RVC. Stop. Mr. N. Ratan, Learned Additional Advocate General, appears for the state respondents. And Mr. M. Kato, Learned DSGI, appears for the Respondent Union of India. Bracket respondent numbers 4 to 6. Next para, this PIL has been filed seeking a direction to include Yobin tribe as the indigenous tribe of the state of Arunachal Pradesh, in view of the fact that the same has not been specifically mentioned in the Constitution, open bracket, Scheduled Tribes, close bracket, Order 1950. Stop. The Learned Counsel for the petitioner submits that for the aforesaid reason, members of the community have been deprived of the benefit of the status of being a scheduled tribe in their day-to-day walks of life. Stop. He therefore submits that the state respondents, the respondents will be directed to incorporate the Yobin tribe as one of the indigenous scheduled tribe of the state. Next para, Mr. N. Ratan, Learned Additional Advocate General, submits that the state government is seized of the matter and they are in agreement with the fact that Yobin tribe is one of the indigenous tribe of the state. Stop. However, as recognition of the Yobin tribe in the Scheduled Tribes Order 1950 would require the approval of the Parliament and ultimately has to be given an accent by the President of the country. Necessary process is being undertaken by the state respondents. Stop. He submits that the matter is to be placed before the state cabinet shortly. And therefore, pending the same, the Learned Counsel submits that he may be given some time receive concrete instructions and then file an affidavit in opposition. Mr. Kato, anything you would like to say?
My lord, as per the instruction, my lord, it is basically has to be done by the state government. My lord. My lord, there is, as per the instruction received from the
Hmm.
ministry.
Have you filed an affidavit?
No, my lord.
You should file then. Let it be on record,
Right.
whatever stand you have.
Yes.
You have received the instructions.
Yes, my lord.
Mr. M. Katolan at DSGI submits that he has received the instructions and may be given some time to file the affidavit in opposition.
Madam.
Next para, considering the, next para. The learned counsel for the petitioner also submits that although the respondents are in favor of, although the respondents accept the fact that Yobin tribe is one of the indigenous tribe of the state, but since members of the community have been deprived of the advantage and facilities available to a scheduled tribe, an interim order may be passed by this court, directing the respondent authorities to honor the scheduled tribe certificate given to members of the Yubin tribe. Next para, considering the above projection and the submissions made by the parties, this court is of the view that passing of an interim order at this stage would should be deferred in view of the fact that the learned additional AG has submitted that the matter is being taken up before the state cabinet shortly. Stop. In view of above, we defer the matter for a month and the case shall now be listed again on so and so. We'll give a date.
My lord.
10th. Just after Bihu on 21st.
21st.
List again on 21st of April. 21st. The affidavit of the respondent should be filed within the next 3 weeks.
Obliged, ma'am.
Well, obliged, my lord.
Item number 3.
Yes.
May Lordship, Lordship, as
What
for
was matter?
matter about prevention detention,
Prevention detention.
Lordship, as per
Under
order,
the NDNPS. You have been detained since when?
since,
January,
yes, Lordship,
28th January. There's an order of 28th January.
Lordship, kindly, we may be allowed to dusty service for respondent number 4.
Okay, who's respondent number 4?
Respondent number 4 is,
Journal Director, Narcotic Control Bureau.
Address, where's the address?
Itanagar, Lordship.
In Itanagar only.
yes, Lordship.
You have taken steps otherwise.
Extra copy furnished to rest of the Lordship, the respondent Lordship, only for Lordship.
We have already extra copy served.
You are appearing for which respondent?
I'm for 3, 5, and 6 Lordship.
3, 5 and 6.
Yes.
DGP, SP, then SP. Prison. Then
One.
Bangu is for 1 and 3.
Yes, sir.
Okay.
And matter was supposed to be listed on 17th of this month, Lordship.
Okay.
It's for the last order.
What is the instruction? Any instruction?
You obtain instruction, Lordship. Yet to receive, Lordship.
See, it's a preventive detention matter, so you complete your instructions as soon as possible.
Yes, Lordship.
NCB, they don't have a standing council?
No idea, Lordship.
They don't have anybody? NCB?
Okay, please write. The parties are represented by the respective councils, except for respondent number 4. Stop. Office note dated 6/3/2026 indicates that notice has been sent to the respondent number 4 by registered post with AD. And also as per, and also as by usual process through CJM UPIA. Stop. However, neither AD card nor unserved notice has returned back as of till date. Stop. The Learned Counsel for the petitioner submits that he may be allowed to serve notice to respondent number 4 by way of Dasti. Prayer is allowed. Petitioner shall therefore serve notice to respondent number 4 by way of Dasti through the registry of this court within 1 week from today, and thereafter file an affidavit to show proof of service. Next para. Since the matter relates to detention of the, who has been detained? Petitioner.
Yes, Lordship. No, petitioner is of
Wife of the petitioner.
Relates to detention of the husband of the petitioner.
No, wife of the petitioner, Lordship.
Lady has been detained.
yes, Lordship.
Okay, wife of the petitioner. Under section, what is the provision? Under section 3 bracket 1 of the Prevention of Illicit Traffic in Narcotics, Drugs and Psychotropic Substances Act, 1988, the learned counsels for the respondent shall obtain necessary instructions by the next date fixed. And file their affidavit in opposition. List this matter again on 1 week.
On the last occasion, it was 17, Lordship. It was fixed on 17/3 of Lordship.
73. Okay.
Maybe another week.
Why then it is listed?
For causing service by Dusty, Lordship. He is praying for Lordship, causing Dusty.
You had mentioned this the other
Yes,
day.
Lordship. Yesterday we have mentioned.
Okay, then list the matter. Today is 10th, isn't it? We'll have it on 24th.
Yes.
List the matter on 24th of March 2026. And in the beginning, you write like this. Although the matter is supposed to be listed on 17/3/2026 in terms of the last court's order dated 5/3/2026, the matter has been listed today on a mention made by the learned counsel for the petitioner. Stop. Then the remaining part, okay?
Yes,
Development.
Item number 4.
My lord, we have received the instructions, my lord. We'll be filing the affidavit totally, and we need some clarifications also.
How much time?
My lord, at least 2 weeks there for the time.
This is the second time it is listed.
Yes, my lord. This is the second date.
Okay, please write. Parties are represented by the respective councils, except for respondent number 5. Mr. N. Ratan, Learned Additional Advocate General, appearing for the state, submits that he may be granted further 2 weeks' time to complete instructions and to file counter affidavit. Prayers allowed. Next para, it is also seen that notice was sent to respondent number 5 through the speed post with registered AD on 6/2/2026. But neither AD card nor unsub notice has returned back. Stop registry to track the postal consignment and put up a note by the next date. List the matter again after 2 weeks.
Obliged, ma'am.
May I please, Your Lordship?
Yes,
I beg to mention item number 13. It's a hearing matter. I'm not prepared today. That's why sometime I require.
how much time?
2 weeks, my lord.
Your good name?
Udeka.
What is your name?
Udeka.
Mr. Yu Deka, Learned Counsel for the petitioner, submits that he requires some more time to prepare the matter and prays for adjournment. In view of above, matter stands adjourned for 2 weeks as prayed for.
Obliged.
May I please, my lord?
Yes.
My lord, I beg to mention item number 14. The council is from Guwahati. So can this matter be fixed on a fixed date?
Which council? Edhar?
Yes, my lord. On 31st of March, I have taken consent from the petitioner,
Your good name?
HK Jammu, my lord.
Mr. H.K. Jamo, Learned Counsel, submits that he is led by Mr. Edhar, who is an outstation lawyer. And therefore submits that as Mr. Dhar has some difficulty to conduct the case today, he prays that the matter be listed on
31st of March.
31st of March.
Highly objected.
Lordship, there's an interim.
The said prayer is not objected to by the Learned Counsel for the opposite party. In view of above, list the matter on 31st of March 2026 for hearing. Stop. The interim order passed earlier shall continue to the next date of listing.
Highly obliged.
All right.
Right, sir.
Yes.
May I please, Lordship? I beg to mention leftover matter, WPC 529/2025, along with IA 39. Actually, which was fixed on 2nd of this month.
Leftover matter, what do you mean?
Leftover matter, it was not heard on 2nd March.
Ah.
Actually, it was fixed on 2nd March.
Uh-huh.
So it has went to leftover.
When do you want it?
So within this week, Lordship.
This week?
Yes,
What
because
is
there
the
is a urgency.
What is the
Because
matter?
matter is that we are challenging this forest clearance and approvals issued in respect of Racing Hydro project, 12 megawatt. So now what is going on? Irreversible damage is going on by continuation of the work.
All right, Mr. Counsel, we'll have it not this week, we'll have it on Monday. 16. You have a mentioned memo with you?
Yes.
Give the date 16.
16.
Yes, 16. Next.
My lord, item number 8. I'm on behalf of Adam Tatak. Ms. Councillor is out of session, so I may get another day for the.
Which council? Adam
Tatak.
Adam Tatak.
Yes.
But there are so many councils.
Yes, yes, my lord. So many again.
I'm also one of the respondents here, man.
I see.
He called me up saying that he has some difficulties, so the matter may be fixed. Yes, fixed on 8.
Yes.
18.
So I already informed the other parties.
You are appearing for which respondent?
Sir,
You're praying on behalf of whom?
Sir, they didn't inform me, sir, properly, sir. Boss.
Adam Tatak appears for which respondent?
पता नहीं मेरे पास ये तो नहीं है आप कौन सा रेस्पॉन्स
हम उसके लिए ना
आप 4M5 के लिए
हाँ
आप 4M5 के लिए
हाँ
आदम तक 6 के लिए होना चाहिए 6 मेरे ख्याल से 6 में 1 2 3 1 2 3 स्टेट है गवर्नमेंट है
Are you agreeable otherwise, Mr. Po?
Yes, my lord.
Okay, as prayed for,
Ma-
on behalf of Mr. Adam Tatak, learned counsel for respondent number
I think so. Six. My lord.
six,
It would be six.
and not objected to by the other side. Let the matter be listed on 18th of March.
Lordship, I'm for the petitioner and there is an interim. Interim may continue.
Interim order passed earlier shall continue till the next date of listing. All right. Any other mention? Yes. What is that?
No,
What is that?
Name.
Oh, name, okay.
Item number 1.
Yes.
My lord, respondent number 456 are the unopposed elected GPM, Gram Panchayat member. From INC ticket, they elected from INC ticket. After being elected, my lord, they started anti-party activity. So consecutively, 2 whips order has been issued so that they should not be against the parties. Thereafter, my lord, when GPC election was going on, my lord, at that moment they claim themselves they have marched from INC to BJP. Change of the party. INC from BJP.
So complaint was given and complaint was dismissed.
Yes.
That's why you are here.
Yes.
Will issue notice? Heard, Mr.
Odugong.
What? Odugong, correct?
Yes.
Odugong, learned counsel for the petitioner, who submits that the respondent numbers 456 are elected Gram Panchayat members. And after the election from the party ticket of the Indian National Congress, they have been acting or campaigning against the state party, and for which 2 party whips were two whip orders had been issued. So despite the same, the respondents concerned failed to adhere to the whip, and therefore a complaint was submitted before the deputy commissioner. What is the deputy commissioner? He is acting as what?
DEO. Defense. Oh, sorry. District Election Commission.
Deputy commissioner, who is also the who is the district election commissioner?
District Election Officer.
Is DEO.
DEO.
District election officer. Stop. Accordingly, a proceeding under section 6(2) of the Arunachal Pradesh Local Authorities (open bracket) Prohibition of Defection (close bracket) Act 2003 bracket as amended was initiated against the private respondents. Stop. While the petitioner was expecting appropriate order to be passed by the state authority, the private respondents, the complaint submitted against the private respondents have been dropped by the deputy commissioner, white order dated 9/2/2026 bracket annexure Roman 6. Stop. Aggrieved, the petitioners are before this court. How many petitioners are there? One only, no?
6. Oh, sorry. One. Only one, sorry.
Petitioners before this court. In view of above, issue notice of motion returnable by 4 weeks. Miss
I'm for respondent number 2.
Miss
K. Wangmo.
K. Wangmo, learned government advocate, accepts notice on behalf of respondent number
2.
2.
Lordship, I'm for 1. State Election Commission.
And Miss
N. Anju.
N. Anju, learned, your standing counsel.
Additional Standing Counsel.
Learned additional standing counsel for the State Election Commission.
Lordship.
Accepts notice on behalf of respondent number
1.
1. Remaining are private respondents, is it?
Lordship.
Petitioner to take steps for service of notice upon the remaining respondents by speed post within 3 days. Stop. Extra copies of the writ petition be furnished to learned counsels appearing for the respondents. Number 1 and 2. Within 2 days. List again after 4 weeks.
Obliged.
Item number 2.
Well, there's a covered case, madam. I have handed over a copy of passed by the division bench. On the last occasion, madam, I furnished. Madam, the petitioner.
What is the subject?
Madam, the writ petition has been filed seeking retrospective promotion. He was given promotion in 2022 from the post of junior engineer to assistant engineer. But along with him, some others were also given a promotion with prospective effect. The writ petition filed by the others were dismissed. Then the writ appeal was filed by them. During the pendency of the writ appeal, my lord, this present petitioner filed the present writ petition because he did not join with them. Now, in the writ petition, lordship will find the writ appeal, my lord.
Writ appeal filed by whom?
Writ appeal filed by others, my lord.
Others means?
Similarly situated persons, my lord.
Their writ petition was dismissed.
Their writ petition was dismissed, then they filed a writ appeal, then the writ appeal was allowed partially. Lordship may kindly have a look at paragraph 3, my lord.
No, before that, you please inform the court what is the matter about.
My lord, matter is, my lord, lordship, then straightway come to the impine order, my lord.
Which page?
Page 93.
93.
My lord.
And who is the petitioner?
He is a
What is he?
Presently he is an assistant engineer.
Assistant engineer.
Yes. He filed the writ petition after he was promoted to the present post of assistant engineer with prospective effect. He prayed that the order should be modified, giving him retrospective promotion.
What is the date you're seeking? Retrospective from?
Retrospective from his officiating promotion, my lord. Date to the I'm just giving the date, my lord. Lordship may just have a look at page 93 of the writ petition, my lord. Date to school. Page.
Yes.
Page 93, madam.
What is this? 93?
This is the order of promotion dated 23rd of June 2022. It says, madam, on the recommendation of the Departmental Promotion Committee dated 10/6/2022, the Governor of Arunachal Pradesh is pleased to order promotion stroke regularization of the following junior engineers to the post of assistant engineer electrical with effect from the date of DPC, that is 10/6/2022.
This is that prospective promotion.
My lord. His name is at serial number 8.
Tango Gongo.
Yes.
Tano Gongo.
Yes.
Okay.
Now he prayed in Lordship may kindly have a look at his prayer, my lord. At page 28.
Twenty-eight. You are from which department?
Power department.
Power department.
Madam. So page 28, my lord, first page, should kindly say, a writ in the nature of statutory shall not issue to the respondent authority for quashing, cancelling, modifying the promotion order dated 23rd of June 2022. Then the second prayer, a writ in the nature of mandamus should not issue directing the state respondents to hold a review DPC to consider the case of the petitioner for giving him promotion to the post of assistant engineer with a retrospective effect. This is his case, madam. Now, Lordship may kindly...
There are private respondents also.
Yes. Page 39, madam.
You want to be promoted before them?
Madam. Madam, page 39 is the order of officiating promotion since when I am paying my retrospective promotion from my lord.
39.
39. 7/7/2011.
How is it relevant, this matter, this date?
This date, because this is the date from which I am seeking promotion to this post with a retrospective effect.
I know. What is how is it on what basis?
Officiating.
Officiating.
Yes.
Where is your name?
My name is my lord.
Go. Okay,
Seal
yeah.
number 9.
Seal number 9. You're there. So what happened to the others?
And that they have got the relief in the before the revision. I'm coming.
The writ petition was dismissed.
Their writ petition was dismissed.
And they filed appeal.
They filed appeal. And the appeal judgment I have ended.
But you said partially allowed. What do you mean partially allowed?
Partially allowed means the matter has been sent. Instead of giving from the Honorable Court, my lord, the department has
Send
been
back.
asked. Yes.
So you want the same thing?
Same.
Okay.
So division bench order, lordship may kindly see, my lord.
Yes. How many were involved here? I mean, only one person, isn't it?
No, my lord. There were many.
Many?
In the retable there was one.
Appeal is what, by one person only?
Yes.
There's another appeal, 3%, 4 total men.
Other appeals are also there.
Total 4 men.
Total 4 persons.
No.
4 appeals.
6 plus 1, 7 men.
7 persons have gone.
Relief in the sense it has been remanded back to the government to ascertain whether vacancies were there or not.
That much only. Because single judge, my lord, dismissed the repetition holding that there are no vacancies available for giving them retrospective promotion.
Okay.
Now the division bench is directed that kindly have a review,
Redo that.
find out if there are vacancies available to give them retrospective promotion, give them.
Okay.
That direction will find, lordship will find at para 26. my lord.
See, my query was otherwise,
My-
that there are a number of persons, say, for instance, your prospective promotion, there are 23 persons, and your officiating promotion has 11 persons.
Yes.
What about the others? You have only shown me one Mr. Martho Kamgo, writ appeal. Anybody has come to the court apart from you and Martho Kamgo?
Yes, 6 others.
6 others, separate
Separate
writ petition,
in the
separate writ appeal.
Writ petition, they came together. In the writ appeal, Marto Kamgo filed separately.
Okay. So this will cover the others also?
Yes.
Okay. If you all agree, we can dispose it of.
Para 26,
Yes,
my
yes.
lord.
In terms of paragraph number
26.
26.
Yes.
Department is directed to redo exercise, man. That part.
To reconsider. Personal benefits. Okay,
Only to the.
we'll dispose it of then
Yes.
without having a very lengthy or detailed
No,
order.
only one thing, my lord. This person has filed writ petition separately because he feels that he has given more documents. He has got many more things to say. So lordship will kindly observe only that he will be when they redo the exercise, he will be given opportunity to file a representation, and there he will include everything. So they will consider representation also
Representation by the
by the present petition.
present petitioner.
Yes,
Then in that case, my lord, liberty be granted to the private respondents also.
always.
All right, all right. All
Not
right,
difficult.
all right. Who's for the power department? We can dispose of?
I'm
In similar manner?
to inform.
Can it be disposed of?
Yes, ma'am.
Okay. Please write down. Since similar matter has been taken up by a division bench of this court and disposed of, the learned counsels for the parties submit that the instant matter, being a covered case, may be disposed of in similar terms. Stop reference in this regard is made to the judgment and order dated
13th February.
13/2/2026,
My lord.
passed by a division bench of this court in WA number 28 of 2024. Open bracket, Martho Kamgo versus State of Arunachal Pradesh and 23 others, close bracket. Next para, heard Mr. D. Majumdar, learned senior counsel, assisted by Mr.
P. Bora.
P. Bora.
My lord, there are 2 appeals. Since your lordship has said there were many others, there are 2 appeals, madam. 3 appeals altogether. Lordship may mention that.
Where? Out here, in this compilation?
Yes, sir. Writ appeal 35 of 2024.
All 3 writ appeals were clubbed together, madam.
Common judgment.
Common judgment.
Lordship will find in the fourth page, my
Then you
page
write,
5.
what did I say? Just a minute. No, yeah, you can say writ appeal number, what did I say? You read from the beginning. Similar matters, yes, have been taken up. To the common judgment. An order dated so and so. Wherein the lead case is WA number 28 of 2024. That much.
That will do.
Heard Mr. D. Mazumdar, Lunch Senior Counsel, assisted by Mr. P. Bora, Mr. D. Pangin, learned counsel appearing for the private respondents.
5 to 24 in WA 28 and WA 35 only, madam. In the other case, I am not there.
In WA?
Yes, WA 28, then WA 35.
No, in this, I'm talking about this case. WPC
I'm sorry, ma'am.
593.
Yes, here, my lord, yes.
You are for 5 to 24, I think.
Yes, here also.
D. Pangin, learned counsel appearing for respondent number 5 to 24, and Mr. L. Perme, learned standing counsel, Power Department.
For 2 and 4.
For 2 and 4, respondent 2 and 4. Miss P. Sangeeta for respondent numbers 1 and 3. Next para. Briefly, the grievance of the petitioner is that he has been promoted on officiating basis to the post of Assistant Engineer Electrical. Right, order dated 7/7/2011, bracket annexure 2. And therefore, his regularization in the said post should be from that date. So therefore, the petition is aggrieved with the order which was issued on 23/6/2022, bracket annexure 16 series, wherein his promotion has been made to the post of Assistant Engineer, bracket Electrical, with effect from the date of DPC, that is 10/6/2022, and not from 7/7/2011. Stop. Similarly situated persons had approached this court, and this court, where's the order? Right. Order dated this court, this court disposed of the such writ petitions Can you give me that judgment? Or is it mentioned anywhere in this writ appeal judgment?
In the first paragraph, it is mentioned, madam.
First paragraph.
First paragraph itself. First judgment was 31/8/2024. My lord may possibly subject to, the lordship may simply mention that the other persons who were promoted prospectively, they filed a writ petition in batches, their petition was dismissed, and then this present writ appeals were
No, dismissed on what ground? That is what I wanted to know.
on the ground that there are not vacancies available.
What did I say last line? Dispose of, what order they did not require? Dismiss those writ petitions on the ground that they were.
My lord, paragraph 25, it is mentioned in the judgment itself. Rejecting the claim of the appellant's petitioner only on the basis of certain file noting may not be proper when the department affidavit is clear so and so. As noted above, the principle of law leads so and so. If vacancy was available, this is the ground.
No, the ground for dismissal.
non-availability of vacancy. In the first sentence, it's made.
But was it verified?
That is the
None
that
available
is
vacancy.
the reason the dividend bench has interfered, my lord.
Now, on what basis was that finding made? On the basis of your counter affidavit?
My
That
lord,
there is no
state-
vacancy.
State government's affidavit was in favor of the petitioners, holding that there were vacancies. But
On the
somehow
ground that there were no vacancies,
available for giving them retrospective promotion.
which was available for giving them retrospective promotion.
Exactly.
To stop the decision of the learned single judge was put to challenge by the parties concerned by filing writ appeal. And all the writ appeals came to be disposed of by the common judgment, an order dated 13/2/2026, with the lead case being WA number 28 of 2024, wherein the division bench held that
Para 26.
wherein the division bench interfered with the judgment and order of the learned single judge and directed the Department of Power and directed the who will do this power.
Department power. Department is equally directed to redo an exercise.
No, department means what?
Power department.
Power alone can do that.
Yes.
Or are you to required to consult with any other department?
No, my lord.
No.
Verification need to be done by us.
Okay, we'll just say department. Directed the department to redo the exercise as regards the availability of vacancy from the date of officiating appointment / promotion of the appellants.
No, officiating appointment only. Yes.
Officiating appointment
Yes.
of the appellants.
Ma'am.
And if such vacancies in the promotional quota in the cadre of assistant engineers were found to be existing, the appellants should be given the benefit of seniority from such date. And that they will be entitled to notional benefits only. Mr. R. Majumdar, learned senior counsel, submits that the present writ petitioner is also similarly placed and therefore squarely covered by the said judgment and order of the division bench of this court. Stop. He therefore submits that the writ petition may be disposed of in similar lines. Stop. He, however, submits that he may be given liberty, the petitioner may be given liberty to file a concise representation before the responding authority concerned to enable the authority to effectively consider the case of the petitioner. To stop, the said submission made by Mr. D. Majumdar, learned senior counsel, is not opposed to by the learned counsels appearing for the other parties as well. Stop. In view of above, the writ petition is disposed of with a direction to the respondent department to consider the case of the petitioner along with the appellants in WA number 28 of 2024,
35.
35 of 2024. What else?
Then 1 of 2025.
One of WA 1 of 2025.
Madam, it's mentioned, madam.
And
That's all.
in terms of the judgment and order dated 13/2/2026 rendered by the division bench of this court. Stop. In other words, the instant writ petition is disposed of in terms of paragraph number 26 of the said judgment and order. The petitioner is also given liberty. The petitioner and the private respondents are also given liberty to submit their respective representation.
And
before
documents
the-
if any. And documents if any.
And documents, if any, before the respondent authority concerned
All will do that.
to facilitate the consideration of their case in terms of the said judgment and order. Any time frame was given? No.
90 days time is given. my lord.
Okay, that is already there. Then you write in terms of paragraph 26 and 27.
Yes.
With the above observation and direction, the writ petition also stands disposed of.
Obliged.
Item number 3.
Your Lordship, in this matter, the engaged counsel is on legs. May it be taken up after some time.
When do you want it?
Let it be taken up after some time, Your Lordship.
Okay, one passed over for the time being. All
Yes,
right.
Your Lordship.
Next case, passed over.
Item number 4.
Hello, here the petitioners before Lordship are the veterinary doctors. Their grievance is that where the doctors, MBBS and other Ayush, Ayurvedic doctor, all have superannuation age of 62 years. So for their concern, it is 60.
Okay.
Now they have been representing from time to time. Now ultimately the department came forward to consider their case. And if your Lordship straightway goes to the in the 5th pay commission also, my lord, central pay commission, it has been considered that they are at par. But in spite of that, my lord, the page 85 your Lordship kindly comes to. Page 85. my lord. The proposal of the department has been re-examined since most of the states, including any states except Manipur, are having the age of superannuation either at 60 years or less. The Department of Administrative Reforms is not in agreement with the request for increase in the age of superannuation for veterinary doctors. This issued with the approval of the Secretary to the Government of Arunachal Pradesh.
This is what you're challenging.
This is what I'm challenging. In fact, this is not an order. It's possibly a file noting and
File noting, huh?
yes, some contribution has been given. This has been mentioned in the writ petition. If your Lordship kindly comes to the relevant part of the writ petition, page 11, page 21. Just I'll read one paragraph, my lord. This will clinch the issue. Page 21, paragraph 11. That the petitioner beg to state that pursuant to a proposal submitted by the Arunachal Pradesh Veterinary Association for enhancement, it is actually a representation, my lord, of age of superannuation. The veterinary doctors from 60 to 60 years in line with the GDMOs, that is General Duty Medical Officers, dental and Ayush doctors. The Honorable Minister AHV has initiated a note wherein it has requested to the Honorable Chief Minister to consider the demand of the Arunachal Pradesh Veterinary Association and allowed it to be placed before the cabinet for consideration and approval. On this, Honorable Chief Minister has endorsed the file to the Chief Secretary, Government of Arunachal Pradesh for examination and discussion. That the proposal for enhancement of age of superannuation of veterinary doctors was examined, and by note dated 15/9/2023, the Department of Animal Husbandry and Veterinary was advised to gather information on the retirement of veterinary officers in other states, particularly northeastern regions, and submit the data to the Department Administrative Reforms for examination for the purpose of potentially increasing the retirement age for veterinary officers. Accordingly, the proposal for enhancement of the superannuation age of veterinary doctors was re-examined, wherein it was observed that the department has furnished information of 10 states and Government of India only. Out of 10 states, 2 states are having superannuation age of 62 years, and 1 state is having superannuation age of at 65 years, but remaining 8 are having 60 or less. That it is pertinent to mention herein that the other northeastern states have their own state pay commission, whereas state of Arunachal Pradesh is strictly adopting recommendation of CPC. This is Central Pay Commission. Ever since its inception in the matter of revise of salaries, allowances.
Just pause there for a moment, Mr. Majumdar. I'm already on page 23.
My lord.
What is this CPC? What is the relevance?
My lord, your lordship is aware.
What is the relevance?
My lord, your lordship is aware in all states they have their own pay commission, and on the basis of the pay recommendation of the pay commission, my lord, everything is decided. pay, allowances, salaries, superannuation age, promotion, etc., etc. Now, so far as state of Arunachal Pradesh is concerned, my lord, they do not have any state pay commission. It is the central pay commission. In fact, my lord, their pay structure also is based on the central government pay structure. So, central pay commission has also made certain observation which is in our favor. I'll show just now, my lord.
Is it not the same thing in other states also? Assam, what do you have?
Assam, we have a state pay
commission.
State pay commission. Central government is not followed in Assam. So here, since we do not have, our pay structure in Arunachal Pradesh is also based on the pay structure of the central government. And the central government pay structure, as your Lordship is aware, on the basis of the recommendation of the Central Pay Commission. And as your Lordship is aware, the recommendation made by the Pay Commission is not binding on the government. It is for the government to take a decision and take a call on its own. And they do it. But that is, they follow that whatever is given, the justification, etc., in the recommendation. Now, since your Lordship has already read this, my lord, my submission is twofold, my lord.
Yes.
One, before that, my lord, I'll just show what is the reply to this paragraph of the department, my lord. Your Lordship, kindly have a look at paragraph 5 of their response, my lord.
Affidavit in opposition?
My
I think there's a separate file.
Yes, ma'am. File by response number 3, my lord.
Number 3.
Paragraph 5, your Lordship, kindly see. Paragraph 11, contentions have been responded to by the...
Who is respondent number 3?
Administrative Reforms Department.
AR, okay.
So paragraph 5, you know, the second paragraph, sub-paragraph. Further, your humble deponent begged to state that agreed to the extent and borne out of the same record that the Department of Administrative Reforms, by endorsement dated 12/12/2023, did not agree to the proposal for enhancement of the superannuation age. It is respectfully submitted that under the rules of executive business of the state government, the Department of Administrative Reforms is the nodal authority for service matters. A proposal cannot be placed before the cabinet without the mandatory concurrence and clearance of the Administrative Reforms and Finance Department. Since the proposal failed to meet the necessary criteria during examination by the expert nodal department, the question of placing it before the cabinet doesn't arise. Therefore, the allegation that the action was arbitrary is denied. Decision of the state respondent is based on comparative analysis of the region as admitted by the petitioner themselves. Out of data collected, most states, including all northeastern states except Manipur, maintain the age of superannuation for veterinary doctors at 60 years or less. The state of Arunachal Pradesh has taken a policy decision to align with the majority prevailing practice in the region to ensure uniformity in administrative governance. The petitioner's contention that the rejection of violates Article 14 by not granting parity with human health doctors, allopathy, dental, Ayush is misconceived. The nature of duties, the criticality of services, and the professional qualification MBBS, BDS versus BVSC are vastly different. Therefore, enhancement of superannuation of specialists and general duty officers of Arunachal Pradesh health services to 62 years shall not be construed as disparity, as because the professional qualification required for doctors of health service and veterinary doctor is vastly different. The enhancement of age for medical officer, doctors, human health to 62 years was driven by a specific exigency and acute shortage of doctors in the state and the need to retain specialists for public health. Such exigency does not automatically apply to the veterinary department. While the state government generally follows the Central Pay Commission recommendations regarding pay scales and allowances, the fixation of the age of superannuation is strictly a matter of state policy. However, parity in pay does not mechanically compel the state to grant parity in the age of retirement. Fixing the age of retirement is the exclusive prerogative of the executive state government. The state must balance the interest of the serving employees with the employment opportunities for the unemployed educated youth. Enhancing the retirement age to 62 years would block recruitment for 2 years, thereby depriving aspiring youth veterinary graduates of employment opportunities. The state government, in its wisdom, has decided to maintain the age of 62 years and to ensure a steady induction of fresh talent. In view of the above, the rejection orders, it is neither discriminatory nor unconstitutional, but it is a valid exercise of administrative power. Endorsement is quoted here. My Lordship has seen the order, my submission is there, my response to this is there in the paragraph itself. The order, the file noting where they have taken into consideration only one thing, what is prevailing in other states. Whereas, in order to finally take a decision, they have to take, as your lordship is aware, the relevant questions. The relevant question here is, if you are giving the superannuation age of 62 years to other doctors, dental, BDS, GDMO, whether it can, you can deny it to me or not, that is the prime consideration. That has not been taken into consideration by the department. Department has collected the materials with regard to the superannuation age in prevailing in other states, whereas the relevant consideration has not been considered. And now, having realized that, my lord, they have filed a writ petition covering all these, the questions which I will be, or the writ petitioners will be raising before your lordship. That these are the relevant considerations. If your lordship calls for the file, relevant file, how they have taken the decision, that itself will make it clear that they have not considered the relevant materials before taking the decision. On that basis, the decision should go, my lord. The department should be directed to take into consideration the relevant considerations, that if the same superannuation is given to others, whether this can be denied to these petitioners. That was not the consideration before the authority when making this file noting. And now, having realized that, they have put it in the affidavit. I need not show those judgments of Mohinder Singh Gill and all, where it says, by filing an affidavit, you cannot improve or you cannot justify the order where you have not taken the relevant considerations. And there are now...
But Mr. Majumdar, how do you say that these were not considered?
My lord, lordship, their affidavit, their order itself is very clear.
This is a noting only.
Noting only. But apart from this noting and the material which the noting seems...
What happened before this or
nothing is there.
Between that?
Nothing is there. They have
that
not...
we don't know. That we don't know.
I don't know. I don't know. But then order itself shows that they have taken the decision only on the basis that it is prevailing, what is prevailing in the other northeastern states except the state of Manipur. Nothing else they have taken into consideration. It is in the affidavit they are saying. But in the file noting or in the consideration of the authority...
So, Mr. Majumdar, sum and substance, I think you broadly will agree the fact that in case of pay matters or in case of superannuation age, as we see in the affidavit, it is the entirely up to the state to decide.
Absolutely.
But such a decision has to be, reasonable and
that is my case.
That is that.
That is my case. And
you are saying that now they have only applied, they have only considered the prevalence in other states, northeastern states.
Yes.
Solely on that point, they have taken this decision.
True, man.
So they have to redo this decision. I mean, they have to reconsider. This is what you're saying, sum and substance.
Yes. And there are two judgments on the exactly on this point. Well, I'll just point out.
Okay. You have given the copy?
Well, I'm giving you a copy. Okay. 2021, volume 17 SCC. Volume 17, SCC, page 642, North Delhi Municipal Corporation versus Dr. Ram Naresh Sharma.
Paragraph?
Paragraph 1, 2, 22, 23. 4 paragraphs, man.
1, 2, 22?
And 23.
Okay.
Small paragraphs, man. I'll just...
Okay.
Judgment by Honorable Justice Rishikesh Roy, man.
Okay.
Paragraph 1, I'm reading, madam. Leave granted, these appeals are directed against the judgment and order dated so passed by the High Court of Delhi, whereby the court upheld the common final order dated so of the Central Administrative Tribunal, Principal Bench, and dismissed the petitions filed by the North Delhi Municipal Corporation. The tribunal declared that the applicants who are Ayurvedic doctors covered under Ayush are also entitled to the benefit of enhanced superannuation age of 65 years, raised from 60 years, just like the allopathic doctor. The entitlement of the respondents to continue in service up to 65 years and receive due remuneration for the same is the only issue to be considered in these cases. Paragraph 2, my lord. Prior to 31/5/2016, the retirement age was 60 years for the general duty medical officers like ours, my lord, of the Central Health Scheme. The dentists and doctors covered under Ayush, including Ayurvedic doctors. At that stage, the Government of India, Ministry of Health and Family Welfare issued order dated 31/5/2016 with immediate effect, enhancing up to 65 years the age of superannuation of the specialists of the non-teaching and public health subcadres of CHS and GDMOs of CHS. This was followed by the consequential amendment of the Fundamental Rules 1922 by the Gazette notification dated so-and-so of the Department of Personnel and Training. On so-and-so, NDMC adopted the Government of India order by issuing office order dated so-and-so and enhanced the retirement age of 65 years for the allopathy doctors working in NDMC. The office memorandum was issued by the Ministry of Health and Family Welfare and so-and-so, then clarified that the enhanced superannuation age granted by order so-and-so is applicable to GDMOs of CHS, that is allopathic doctors and municipal corporations, and others were given the liberty to take their own decision on the matter, on the applicability of the ministry's decision on enhancement of superannuation age. Thus, the Ayurvedic doctors were not seen to have been covered by the ministry's order so-and-so. Now, straightway I go to para 22. The para 22. The common contention of the appellants before us is that classification of Ayush doctors and doctors under CHS in different categories is reasonable and permissible in law. This, however, does not appeal to us, and we are inclined to agree with the findings of the tribunal and the Delhi High Court that the classification is discriminatory and unreasonable, since doctors under both segments are performing the same function of treating and healing their patients. The only difference is that Ayush doctors are using indigenous systems of medicine like Ayurveda, Unani, etc., and CHS doctors are using allopathy for tending to their patients. In our understanding, the mode of treatment by itself under prevalent scheme of things does not qualify as an intelligible differentiator. Therefore, such unreasonable classification and discrimination based on it would surely be inconsistent with Article 14 of the Constitution. The order of Ayush Ministry so extending the age of superannuation to 65 years also endorses such a view. This extension is in tune with the notification of so-and-so. Para 23. The doctors both under Ayush and CHS render service to the patients, and on this core aspect, there is nothing to distinguish them. Therefore, no rational justification is seen for having different rates for bestowing the benefit of extended age of superannuation to these two categories of doctors. Now, there is another judgment of Madhya Pradesh. There is another judgment of Madhya Pradesh High Court. They are, my lord, absolutely same. They were petitioners were veterinary doctors only.
This was between Ayush doctors and the
My lord?
Ayush and allopathy.
allopathy.
Yes, yes.
Allopathy was given the advantage
Yes.
of 65.
Yes.
Ayush also came to be.
My lord, now this one is petition by the veterinary doctor.
No, one thing which I don't understand here, the court also said that it did not agree, Apex Court. And then it also says that
Reasonable classifications.
this is in tune with the notification of Ministry of Health.
My lord,
No, the order of Ayush Ministry.
my lord, what has happened? Ayush Ministry has given extended age to some of the persons, but and say that your lordship will kindly see here. The first paragraph says, appellants who are Ayurvedic doctors covered under Ayush are also entitled to the benefit of enhanced superannuation age of 65 years, raised from 60 years, just like the allopathic doctors. That was the contention.
Then who were
The entitlement of the respondents to continue in service up to 65 years and receive due remuneration for the same is the only issue to be considered. So Supreme Court ultimately agreed that all are entitled to same treatment.
No, who was not given the similar treatment? Which
Well,
doctors?
Ayush Ayurvedic doctors.
Ayurvedic.
Yes, madam.
So tribunal has decided in their favor only.
In their favor, and Supreme Court also held the tribunal was right.
So the municipality had come before the Apex Court.
Yes, madam.
Okay.
Their contention was rejected. Now this Madhya Pradesh High Court, my lord, is by
Then again at paragraph 22, order of Ayush Ministry dated 24/11/17,
my lord.
extending the age of superannuation,
Yes.
also endorses such a view.
Yes.
Ayush Ministry also was agreeable.
No, my lord,
Who had prevented them from retiring at 65?
my lord, this paragraph 2 towards the end, Lordship will find last sentence. I'm just reading this paragraph 2 to make it so that it becomes clear, my lord. Prior to 31/5/2016, retirement age of 60 years for the GDMOs of the Central Health Scheme, the dentists and doctors covered under Ayush, including Ayurvedic doctors. At that stage, earlier it was same 60 years for all. At that stage, the Government of India, Ministry of Health and Family Welfare issued an order so and so with immediate effect, enhancing up to 65 years the age of superannuation of the specialists of non-teaching and public health cadres of CHS, GDMO, CJ. This was followed by consequential amendment of the fundamental rules of 1922 by Gazette Notification so and so. On 30th of June 2016, NDMC adopted the Government of India order by issuing office order so and so and enhanced the retirement age of 60 years for the allopathy doctors working in so and so. So it was extended to only allopathic doctors and not to others. Tribunal said no, it has to go to all.
Okay. All right.
My lord. This judgment of my lord 2025, very recent, my lord, of 19/5/2025 by Madhya Pradesh High Court is very relevant. I am just straightway taking your lordship to paragraph 34, which is last page, my lord, of the last page of this bunch.
Yes.
There is no anomaly between the allopathic doctors and Ayush doctors so far as their age of retirement, that is 65 years, is concerned. By the impugned amendment, age of retirement of medical doctors has been increased to 65 years, and the Ayush doctors are also enjoying the benefit of enhancement of the age of retirement up to 65 years by the Gazette Notification dated so and so issued by the Government of India, Ministry of Ayurveda, Yoga and Naturopathy, Unani, Siddha and Homeopathy. Merely saying that the allopathic doctors and Ayush doctors are treating human patients by adopting their own method cannot be equated with the veterinary doctors as they are treating non-human patients, as is our case, man, is not acceptable. The Madhya Pradesh Veterinary Services Gazette Recruitment Rules 7 outlined the regulations for recruiting Gazette veterinary officials in the state. These rules, which were amended in 2011, are based on the 1966 rules. The 2007 rules cover aspects like eligibility criteria, selection process, and other related details for gazetted positions with the veterinary services. In our view, a veterinarian or veterinary surgeon is a medical profession who practices veterinary medicines. They manage a wide range of health conditions and injuries in non-human animals. Article 14 of the Constitution of India, which guarantees equality before law and equal protection of the laws, can be used to challenge age-based retirement policies that are considered discriminatory. While the government has the right to set retirement policies, these must not create arbitrary or discriminatory classifications. Specifically, any classification based on age must have rational nexus to a legitimate objective. Supreme Court of India recognizes the intrinsic value and right to life of animals, stating that their life extends beyond mere survival, encompassing dignity, honor, and the ability to live peacefully. The Supreme Court has incorporated this into the legal framework, expanding the interpretation of life and under Article 21 of the Indian Constitution to include animals. The Supreme Court has addressed the rights and duties related to animals' welfare, including veterinary services, in several cases. One notable case is so and so. In view of the above discussion and settled position of law, we have the considered view that the claim of the veterinary doctors in respect of enhancement of age retirement should be at par with the allopathic doctors and Ayush doctors. In consequence thereof, the impugned amendment, so far as it excludes the veterinary doctors, depriving of benefit of enhancement of age of retirement up to 65 years, is declared discriminatory and unconditional on the principle of equality granted under Article 14 of the Constitution of India. Consequently, we direct the state government to come up with appropriate provision and rules fixing the age of retirement of veterinary doctors up to 65 years at the earliest. Till then, the judgment shall hold the field. So, my lord, in this case, the Honorable High Court itself has granted it instead of sending it to the department. And in our case, my lord, the department has not taken into consideration anything which is relevant here. And this Honorable Court has said, the Honorable Supreme Court has already held that you cannot differentiate between the obligation of the state to maintain the health of the human being in the similar way the health of the animal. This being the position, my lord, my humble submission before your lordship will be that the present petitioners who are veterinary doctors, only because they treat animals, they cannot be discriminated and they are entitled to the same age retirement pension.
Yes. Mr. Apang. I'm sorry, Apang. Mr.
My lord, may I suggest, my lord, the veterinary department, they have the studying council, my lord. After the submission, my lord, I'll
Okay, okay.
address you.
Sure. You are power also. You are veterinary also.
Both, my lord.
Very powerful.
So our department is concerned, my lord. We are in favor of petition and my lord.
You are in favor?
Favor, my lord. Now, I find this, my lord, as we as a department, my lord, is in favor of petition and my lord. Now, objection is by the other department. This is air department.
AR department.
Air, my lord. Now,
it went to the AR department. It did not. Beyond that, it did not.
No.
Beyond that, it was supposed to go to the cabinet also.
Yes, my lord. My humble understanding.
The AR said that no, it's not possible.
This AR is also a separate department, my lord. It cannot be both of the other department, my lord. So when there is a dispute between two departments, my lord, at least I find this need to be placed before the cabinet, my lord.
See, I don't know what is the situation here, but as per your conduct of business, allocation of business rules or whatever you call it.
My lord, we have that, my lord.
Any proposal or anything with financial implication has to, like manpower, financial implication, has to be channelized.
Yes, my lord. That is
through the AR.
Yes, AR and finance also, my lord.
And finance.
Yes, my lord. That is there, my lord.
And has to be vetted by the law also.
Yes, my lord.
So this is the system only.
System, my lord. Now, in the
that both the departments are fighting each other.
Yes, my lord. In the situation, my lord, when department fighting, my lord.
But that kind of rules also do provide. In case there's a disagreement between departments, how it is to be dealt with, it must be there.
I'm not sure of that, my lord. But
it has to be there because
my humble
each department also has their own interests.
My humble understanding, my lord. In this case, my lord, file was initiated by the concerned minister, my lord. Now that was routed to a file, my lord. Initial file was initiated by the through minister, my lord, of the department, my lord. Now that was routed through, my lord, SIM minister, my lord. Now at that stage, my lord, I find, my lord, at least that can be termed as a sub cabinet, my lord. Sub cabinet, my lord. One decision by the concerned minister and the CSC minister, my lord. That decision will be sub cabinet decision, my lord. Amount to be cabinet decision, my lord. Now here is again,
Mr. Perma, is there any such kind of possibility that one minister puts up the thing and it becomes a sub cabinet?
No, my one minister approved by the concerned SIM minister, my lord. In emergency situation, my lord, rule provide, my lord. Cabinet.
What do you mean by sub cabinet?
Sub cabinet by the means by the SIM minister and the minister concerned of the department, my lord. That decision is sub cabinet decision, my lord. Now here is a case, my lord, sub cabinet, though that was not in form of the written, my lord, but as this file passed routed to concerned minister, my lord, he approved, my lord, and that routed to, my lord, CM also, my lord, and knowledge the chief minister also, my lord. Now it is only in the below portion, my lord, this has been installed, my lord, in the department, my lord. So I humbly believe, my lord, it's a big case, my lord, where this issue, my lord, can be placed before the cabinet, my lord, for appropriate decision, my lord.
That's it?
Yes.
Yes. Nava.
My lord, before I address your lordship, my lord, I want to just tender an apology to Mr. Majumdar, Land Messenger Council. My lord, last week all the way from Guwahati, he came to Itano to address your lordship in this matter, but because of my ill health, my lord, I could not attend, my lord.
Today we are.
And that, having said that, my lord, there is also another submission from his side, my lord. Perhaps, my lord, that may not be warranted. And I'm told that he suggested the Honorable Court, my lord, that I should not take up this matter and somebody should be, my lord, engaged, my lord. I don't know, my lord, how far that information is correct, my lord.
I did not say so.
And, maybe, my lord, I got the wrong information, my lord. Because even I, my lord, never expect that Land Messenger Council will submit that way, my lord.
No.
Anyway, my lord,
On health ground, we never oppose. If an adjournment is sought on health ground, we never oppose.
that exactly my junior informed me, my lord. So even I got shocked, man. How come Mr. Majumdar can address it on the court? Anyway, my lord. Man, coming to the, my lord, matter, my lord. Now the Land Senior Council.
Let me clarify, since my learned has says so much. On the last occasion, when my learned friend was not there, the learned council, standing council said AG will appear in this case. I thought if AG appears, another AG is available, he can appear. I didn't know that already one AG is appearing. So that is the context in which I said that.
No, he didn't say so.
He said,
Okay, let us forget it. Okay. Be gone, by gone. Let us forget it.
Let us not go into that.
Yes.
Let us not look back, my lord. Now, my lord, coming to this point, my lord, what the other side had addressed, my lord. My lord, admittedly, my lord, we don't have a pay commission, my lord. Like Assam, they have, my lord. We follow the central pay commission subject to the, my lord, financial sound. In ditto, my lord, we never copy paste, my lord. Subject to the availability, my lord. So, in that, my lord, situation, my lord, it would be wrong to say that we follow the central pay structure. No, we don't follow that, my lord. That was following for the other side, but we follow the pay structure of central government. We don't follow that. Now, my lord, coming to, my lord, this comparison between, my lord, what the others said, human and animal, my lord. Admittedly, my lord, we are social animal, but we are not domestic royal animal. Now, my lord, right from the, my lord, beginning, from the courts itself, my lord, they are totally, my lord, different, my lord. The subjects are different, my lord. Their recruitment rules are different, and their, my lord,
See,
sanction posts are different, my lord.
Mr. Nabam.
Fees are different, my lord.
Mr. Nava, let me just interrupt you.
My lord.
See, I'm sure you have many lines of justification, all that. And your affidavit also speaks a lot of justification of the decision take. But one thing I would like to know is the particular office file note, which says that this is the situation in this state, in this particular state.
Yes, my lord.
In Manipur and other northeastern states. So,
Taking example of entire northeast region, my lord.
So, isn't this too narrow a compass for applying for consideration?
My lord.
So, in other words, what I'm saying is that why shouldn't you reconsider this matter?
My lord.
In the light of, like many other aspects like the pay and other factors which are there.
My lord.
Not basically just seeing your surrounding and the others are not doing, we also not do like that.
If you take
Let there be a proper justification. And court will not give a positive direction that you should give it.
My lord.
It is entirely up to you.
Correct, my lord.
Unlike the Madhya Pradesh High Court, perhaps court may not take up.
Your lordship is very much ever, my lord. Now all these, my lord, rules, service conditions, my lord, they all are framed under Article 309, which gives the power to the parliament as well as the legislature to legislate, my lord. So this being a policy, my lord, decision, my lord. Now, what exactly your lordship question is following, my lord? Can there be broader, my lord, observation? My lord, what the other side they have said and others have said, my lord. Now, when you see, my lord, this, your lordship was asking, my lord, we have, my lord, Arunachal Pradesh rules of executive business. When you see that, my lord, AR department is the nodal department for any pertaining to the recruitment rules. And finance department, then law department. These are the three departments which are very important role to play, my lord. once these things are sorted out, or my lord, if there are any negative, positive observation, like the air department they have met, my lord. Now, my lord, let there be assume, my lord, there is a dispute between my lord, air department and the health department. Now, what could be, my lord, mechanism to sort it out? That was following your lordship, my lord. Now, when we see, my lord, this executive business rules, there is a mechanism, my lord, the chief secretary, my lord. The chief secretary will decide, my lord, whether it should be placed before the cabinet or not. He will take the assistance from the air department, finance department, and law department. After getting all feedback, my lord, then the matter can be placed before the cabinet, my lord. Now, cabinet being the highest policy making body, my lord. So these are, my lord, extending the, my lord, service danger, my lord. It will be a policy decision, my lord. Exactly, they are asking for that, my lord. So if your lordship feels, my lord, that there needs to be little bit more, my lord, broader sense of observation, that can be done, my lord.
Okay, we'll coordinate direct, you see. We'll make it very brief.
My lord.
Instead of, like explaining everything. It is up to the state to take a call on this.
Final call, absolutely.
But let all the ingredients, let all the materials be there before them.
Yes, ma'am.
And let them take a call. All right, I think that will be the best. Okay, please write down. All right, Mr. M. Majumdar.
I'm D. Majumdar.
D. Majumdar, sorry. Learned Senior Counsel, assisted by Mr. P. Bora. For the petitioner, Mr. N.H. Nabam, Learned Additional Advocate General.
RH, my lord.
Sorry. Mr. R.H. Nabam, Learned Additional Advocate General, Arunachal Pradesh, and Mr. L. Perme, Learned, you're standing counsel?
Yes.
Standing counsel, Veterinary Department. They're paying for respondent number 4. Stop. Grievance of the petitioner briefly is that they are members of the Arunachal Pradesh Veterinary Association, and registered under the Societies Registration Act 1860.
Last week.
And having completed the required degree in the line of veterinary, they are serving under the Veterinary Department, Government of Arunachal Pradesh. And therefore, they are entitled to be considered for enhancement of the retirement age from 60 years to 62 years, is it?
Yes.
My lord, my lord.
Similar to the specialists and general duty medical officers working under the state government. Although a proposal for enhancement of the age of superannuation was initiated, but the same came to be negated by the Department of Administrative Reforms. On 12/12/2023. Bracket annexure Roman 9 bracket capital A. of Mr. D. Majumdar, learned senior counsel, drawing the attention of this court to the said decision, submits that the Department of Administrative Reforms appears to have taken a decision not to give the benefit of enhancement of age of superannuation from 60 to 62 years solely on the basis of comparison with other northeastern states except for the state of Manipur. He submits that due to the decision taken by the Administrative Reforms Department, the matter could not be placed before the state cabinet. And thereby depriving the petitioners, members of the petitioner association, their right to be placed at par with other similarly situated persons working under the Health Department, Government of Arunachal Pradesh, as specialists and general duty medical officers. Stop. The learned senior counsel submits that although the respondent number 4 respondent number 3, sorry, in their affidavit of position filed on 27/1/2026 had given a detailed explanation
Paragraph 5, my lord.
as to why the members of the petitioner association cannot be given the benefit of enhancement of the age of superannuation. But such justification is not discernible from the decision taken by the Administrative Reforms Department on 12/12/2023. Wherein the sole ground for rejecting the prayer for enhancement of superannuation age was on the basis of comparison with other neighboring states. He submits that under the circumstance, the decision taken should be interfered with by this court. The learned senior counsel also submits that comparison has to be drawn not only with the counterpart of the petitioners, members of the petitioner association in other states, but also within the state itself, wherein the
GDMOs and dentists. They are
General duty medical officers, comma, dental officers and Ayush doctors have been given the benefit of superannuation at the age of 62 years. Stop. He submits that not only this, the recommendation of the Central Pay Commission should also be taken into account, since the state does not have its own pay commission.
And admittedly, they follow this Central Pay Commission recommendation.
And admittedly follow the Central Pay Commission.
They are stand in the affidavit.
Stop. Therefore, taking all these factors into account, and the fact that the members of the petitioner association have a right to be treated at par with other similarly situated employees. Similar benefit should be given to them. And failure to do so would be an infringement of their fundamental right as guaranteed under Article 14 of the Constitution of India. So the Learned Senior Counsel submits that in fact, on a similar issue, the High Court of Madhya Pradesh had decided in favor of the veterinary doctors of the state by holding that they are also entitled to be given the enhancement of age for retirement at par with allopathic doctors and Ayush doctors. Stop. In this connection, the Learned Counsel relies upon the case of O.P. Singh versus State of Madhya Pradesh, 2025 to JLJ 532. So the Learned Senior Counsel further submits that a similar issue had also cropped up when the Central Administrative Tribunal Principal Bench had decided that the Ayurvedic doctors covered under the Ayush are also entitled to the benefit of enhancement of superannuation of age from 60 to 65 years, like the allopathic doctors. Stop. Against the said decision, the North Delhi Municipal Corporation approached the Apex Court, and the Apex Court upheld the decision of the Central Administrative Tribunal Principal Bench. By holding that the classification sought to be projected by the municipal corporation was not based on intelligible differentia, and thus an unreasonable classification which can be construed as discrimination and not inconsistent with the equality clause under the Constitution of India. So the learned senior counsel submits that the decision squarely covers the case of the instant petitioners as well. And therefore, interference of this court is also warranted in the present case. In making his submission in this regard, the learned senior counsel refers to the decision of the apex court in North Delhi Municipal Corporation versus Dr. Ram Naresh Sharma and others, 2021, 17 SCC 642. Next para. Mr. L. Perme, learned standing counsel for the veterinary department, submits that in fact the department supports the cause projected by the petitioner association, and in fact it was the minister in charge of the state department who had moved the file for consideration and placement before the appropriate authority. However, in view of the decision arrived at by the Department of Personal Administrative Reforms, not personal, administrative reforms, the proposal did not find favor. For being considered and put up before the competent authority, that is the state cabinet. He therefore submits that under these circumstances, court may consider the same and pass appropriate orders as it deems fit and proper. Next para, Mr. R.H. Nabam, learned additional advocate general, submits that the state government is within its competence to decide the age of superannuation in the present case as well. No, he submits in the present case, you cancel that. He submits that in matters relating to employment or where the services of the government employees are concerned, the same has to be routed through the Department of Administrative Reforms, who then examines the same and accordingly takes the matter forward.
My Lord, Your Lordship, just referred by AR department. Your Lordship may kindly add one more thing, my Lord. We have, my Lord, Arunachal, the rules of the executive business. 1987. As per that, my lord, the AR department is the nodal department. All, my lord, pertaining to service condition has to be routed through AR department.
2000?
My lord, is
Which year?
Arunachal Pradesh Rules of Executive Business, 1987, my lord.
That's the year when statehood was given.
Statehood was given, correct, my lord.
Okay.
So as per this business rules, my lord, all pertaining to my lord, service, it has to be routed through the nodal department, that is air department. Then I have also said, my lord, admittedly we follow the, my lord, Central Pay Commission, but we don't follow in detail.
That I've noted.
Yes, my lord. Then also, my lord, pay scale of central, my lord, we don't follow, my lord. We have our number mechanism, my lord. Then you will also reflect, my lord, paragraph 5, my lord, the department is state, my lord.
Yes.
The taken by.
Accordingly, the department decides as to whether the matter should be taken forward or should not be. Stop. In this connection, the learned additional AG submits that the state government has framed the Arunachal Pradesh Rules of Executive Business, 1987, which is the guiding factor for government to take a decision insofar as service of its employees are concerned. He further submits that although he also submits that the state government does not have a pay commission of its own and thus rely upon the Central Pay Commission. But however, the Central Pay Commission is not applicable in toto, and the state government does not follow the same.
That is not the correct position of law. My correct position is recommendations of the any pay commission, be it state or central, is not binding on them. It is only a guide.
Recommendation.
Recommendation.
Is not followed in toto, as the same is not binding upon the state. However,
they take their own decision.
The state government, therefore, takes its own decision and
Taking the aid from the recommendation. Otherwise, you do not have any pay commission.
I think with certain modification,
Yes, my lord.
Yes.
takes cue of this CPC, Central Pay Commission, with certain modification,
If necessary.
which is suitable for the state.
For a state, my lord.
He also submits that the stand of the government has clearly been highlighted at paragraph number 5 of the counter affidavit. And therefore, under the circumstance, no interference of this court, no interference from this court is called for. Next para, the rival submissions made by the rival parties have been duly considered. Take no doubt is entitled to take a decision as regards the service conditions of its employees. But the fact remains that such a decision should be taken by taking into account all relevant facts and circumstances connected with the issue, which in fact has been pointed out by the respondents themselves with paragraph number 5 of their counter affidavit. However, it appears, on the other hand, that a decision has been taken not to extend the benefit of enhancement of the age of superannuation for veterinary doctors by through the impugned decision dated 12/12/2023 taken by the Department of Administrative Reforms by drawing a comparison to other states of the Northeast, excluding Manipur. To stop, in other words, the exercise of in other words, the process of embarking upon an exercise of due consideration by taking into account the counterparts of the members of the Petitioner Association in the Health Department, particularly in regards to the nature of duties performed, the criticality of the services, the professional qualifications, amongst others. Appears to have not been considered before coming to the impugned decision. Stop this apart. The decision of the Apex Court in North Delhi Municipal Corporation Supra and also of Madhya Pradesh High Court in OP Singh bracket doctor and others Supra are found to be relevant considering the cause projected by the members of the Petitioner Association. Therefore, upon due consideration, this court is of the considered view that the grievances projected by the petitioner or the claim of enhancement of their age of superannuation by the members of the Petitioner Association requires to be revisited by the respondent authorities. By taking into account all relevant factors. Anything else to be added?
That is all about the Central Pay Commission recommendation. I have annexed the extracts. The Central Pay Commission also has recommended to treat them at par, even with regard to the age of superannuation. I have annexed the extract.
Would you like to submit something to assist the authority to take a decision.
My lord, here, my lord, although it's a matter of policy, but the decision has to be taken by taking into consideration the relevant considerations. Now here, their counterpart in the GDMO, in the dentist, they are all getting. There is no any intelligible differential based on which they have been discriminated. So Lordship will direct them to treat them in a fair manner, because if your Lordship direct them to consider them at par, because there will be a specific direction. Otherwise, Madhya Pradesh High Court has given a specific direction. So at least something so that, my lord, a decision is taken, my lord. Otherwise, they are directly, it's apparent that they have been discriminated.
Including the, you're right, including the recommendation of the Central Pay Commission. Which admittedly is applied in the state in a modified form. Such consideration should be done within a period of
My lord, within the period of my lord, your lordship had said, my lord, official respondents, my lord. My lord, which official respondent? There are three respondents are there, my lord. One is, my lord, Health Veterinary Department, AR Department, then Finance Department, my lord.
My lord, here, although the collection of materials, etc., will be done by the Administrative Reforms Department, but ultimately it will be a decision of the government, because finance has to come. So Lordship will simply say the state respondents, so that
That's
all
what-
comes in.
all of you are the
Yes.
government.
Yes.
You cannot single out anybody.
Yes.
Because AR will say, okay, we need some more document. Give us that document, that document. You might have to trouble the veterinary department also. They'll have to supply you. And what about finance? Then finance also may have to be referred to.
My lord, we sought instruction from the Finance Department. My lord, they have simply said this matter pertaining to Air Department. Once Air Department clears, then, my lord, the financial, my lord, department.
Because you have taken one stand here, saying that if enhancement is done, that means the new generation, new people cannot come in. And people who's gone, they're going to hang on longer for 2 years.
Not exactly harassment, my lord. Your lordship knows, my lord, reasonable classification is permissible, my lord.
The state respondents shall therefore take a decision, consider the case of the members of the petitioner session in terms of the observations made here and above,
Within the period of 3 months, my
and
lord.
take a decision in the matter within a period of 3 months
months,
from the date of receipt of a certified copy of this order.
My lord,
All
the indication your Lordship is given that even if the action is necessary to be given to the department, and my submission will be the recommendation of the 5th and 6th Pay Commission, which are very apparent. Lordship will just give them one direction that recommendations of the 5th and 6th Pay Commission may be taken into consideration.
CPC
They
has
have to
already
take a
said-
decision.
I have already said
Yes, sir,
CPC.
Some possible action that the recommendations are already there, so Lordship will direct them to.
Central Pay Commission, I said, no, the last part. You may indicate 5th and 6th. 5th and 6th Central Pay Commission. But now we are not in 5th and 6th.
We are in 8, my lord.
We are in 8 now.
Yes, sir.
True, madam.
I think CPC is enough if you
Yes.
refer to a particular, not required.
CPC is enough.
Otherwise, they will say that, okay, we have gone by 5th and 6th, there's nothing
Now,
there for you.
yes.
So it will not be to your advantage. Okay. With the above observed, I'll dispose. Huh? Okay.
I'm sorry for interrupting, my lord. I understand your lordship will not be sitting in the
Yes, I have some other
Item
engagement.
number 5, my lord, there is some urgency. We taken up day after tomorrow.
Item
Next
5.
item, yes.
Just
A short matter, my lord.
this was item number
This was 4, my lord.
4, my lord. Okay, na, please, ito.
item number 5, but I don't know.
It will not take long, my lord. It's regarding suspension of Gaon, your lordship will recall, in fact, your lordship will issue notice. There is no power to the government to suspend a Gaon, my lord.
Okay, item 5, as prayed for, list this matter on Thursday. Give the date.
My lord, item number 3, my lord. Can it be taken up after 2 weeks, my lord? Because the petitioner was dismissed from service, my lord.
All right. Huh? Veterinarian.
Yes.
Veterinarian.
How is it registered in the Societies Act? Let's see the name, nomenclature. You have annexed it somewhere?
Registration.
Ah. It says Arunachal Veti Association.
The
Veterinary.
name of the petition is all right. They have been registered as such, but they are only affiliated to Indian Veterinary Association.
No, what is the name of the association?
Arunachal Pradesh Veterinarian Association.
Not doctor.
Okay. But the main cause is the veterinary doctor,
Veterinary doctor.
not the other.
Not others.
They are espousing the cause of veterinary.
Not others.
Arunachal Pradesh Veterinarian Association. Okay, the remaining matters which are there, Court Master will see and give you a date. Any interim order, you please reflect that. Okay.
Wait, please, my lords.
Yes.
I thought of taking the liberty to appear face to face. So obliged, my lords. My lords, this is a bail application under NDPS Act. I've been charged under sections 21C, 25, and 29 of NDPS.
My lordship, if I may, lordship, before we proceed on, lordship,
Yes.
if I may kindly be allowed 1 week's time, my lord, to file my objection, my lord. I receive it today itself, my lord.
Oh, you have not filed your objection?
I have not filed, my lord.
But on the last occasion, they sought time. It's a reasonable time, my lord. And the only issue is that I've already been behind bars for 2 years, 10 months, 9 days. And the
Last
case was
time,
also
my
filed.
lord, the last court date was my first appearance before your lordship, my lord. Earlier, it was the state prosecutor who was appearing, my lord. And since it was transferred to NCB, my lord, this is the second time, my lord, I appeared before your lordship. So if I may kindly be allowed 1 week's time, my lord.
My lords,
I receive instruction, man.
my lords, last time also someone accepted notice on behalf of NCB. I think my learned colleague
Yeah,
appeared.
I accept, my lord. I accept. I received it last time, my lord. Only last time, my lord. And
My
today,
lords, the limited issue was only with regards to serving of section 47 and 48 notice. I've already annexed those notices, my lords, that I'm sure they will not dispute. So only on that limited point, I'm praying for bail. So to the extent that is admitted that I have not been served the grounds of arrest, as well as to the relatives, nothing more survives to adjudicate, my lord. So that objection that my learned colleague is planning to file will have no bearing on this case, my lords. So it's an admitted fact. So my lord peruses the arrest memo. It's clearly written that it has been intimated, the grounds are intimated, but it is not reserved in a written form. Therefore, that is my only grievance, my lords. On that ground, I should be granted bail. That's a very limited issue. There is no factual adjudication that is required further, my lords, in this matter. My lords, may kindly peruse the arrest memo, the report at page 22.
22.
This is the report of seizure and arrest. Page 22, my lords. If I may draw my lord's attention to the third paragraph. The possessor was arrested by preparing proper arrest memo. After informing her grounds of her arrest, intimation of her arrest was also communicated to his brother Abdul Hakim Laskar. The word is communicated, my lords. And the arrest memo, my lords, can kindly come to page number 19, just a few pages prior. The relevant portion is at page 20.
If I may, lordship,
My
I
lords has the page.
regarding that since now the time of arrest, lordship, was prior to the Pankaj judgment, lordship. So it doesn't it seems
my
my lord,
lords.
this judgment doesn't cover the present case, my lord. So for
No, my lord.
all these grounds, my lord,
Well, the judgments of the
my
Supreme Court will always have retrospective effect. That's a settled law. He cannot now say that this pronouncement of the Supreme Court will not have
Regarding the
retrospective effect.
present
Any detention that has been made
judgment,
illegal
my
in
lord,
violation of 47, 48
the apex
is
court
rendered illegal,
says
my
that
lord.
it has
It's
to
very
govern
categorically stated in Pravi Pura question Vihan Kumar, my lord.
prospectively only, my lord.
Therefore, that submission cannot be accepted in my humble submission, my lord. And my lord, kindly peruses page 20. They have clearly written.
My prayer, my lord, is for filing
My
objection.
lord, it's written, the accused.
Just a minute, Mr. Zoram Chana. Just a minute. I've heard you. You have a prayer for adjournment
My lord.
for singing for filing objection. Have you informed the other side in advance?
No, my lords, we are not informed.
We should have you should have informed them also.
We have taken the
So that no inconvenience is caused to the parties, traveling here and there.
My lords, page 20, it's clearly written. The accused, after being informed of the grounds of arrest and his legal rights, were duly taken into custody on 2/5/23 at 9:30 p.m. hours at Special Narcotics PS. Then we're down below, my lord. Necessary wearing apparels were left on the accused person for the sake of human dignity and body protection. The accused was cautioned to keep himself or herself covered for purpose of identification. This is relevant, my lords. Intimation was given to Abdul Hakim Laskar, relationship brother. Now, my lords, peruses the judgment of Pravi Purakashtra, my lord. I'm passing a copy of the order, my lord. My lords, may I kindly take my lord's kind attention to para 22 at page 25 of the judgment. If I may kindly read, my lord, if my lord has that page.
Yes.
The right to be informed about the grounds of arrest flows from Article 22, Clause 1 of the Constitution of India, and any infringement of this fundamental right would vitiate the process of arrest and remand. Mere fact that a charge sheet has been filed in the matter would not validate the illegality and the constitutionality committed at the time of arresting the accused and the grant of initial police custody remand to the accused. Here it's clearly stated by the Honorable Apex Court that whatever arrest was done, that would be rendered illegal by the very non-furnishing of the grounds. Further, my lord, learned ASG referred to the language of Article 22, Clause 5 of the Constitution of India and urged that even in a case of preventive detention, the constitutional scheme does not require that the grounds on which the order of detention has been passed should be communicated to the detainee in writing. Ex facie, we are not impressed with the said submission. That is exactly the submission that the learned PP is trying to make before his court today, my lords. The next para. The contention advanced by learned ASG, based on the language of Article 22, Clause 5 of the Constitution of India, persuaded us to delve deeper on the issue as to whether it is mandatory to communicate the grounds of arrest or detention in writing to the accused or the detainee, as the case may be, even though the constitutional mandate under Articles 22(1) and 22(5) of the Constitution of India does not expressly require that the grounds of arrest should be communicated in writing. A constitution bench of this court examined in detail the scheme of 22(5) of the Constitution of India in the case of Harikishan versus State of Maharashtra and others, and held that the communication of the grounds of detention to the detainee in writing and in a language in which he understands is imperative and essential to provide an opportunity to the detainee to make an effective representation against the detention, and in case such communication is not made, the order of detention would stand vitiated as the guarantee under 22(5) of the Constitution was violated. Then the relevant para was reproduced, my lords. Then in the next paragraph, further, this court in the case of Lallu Bhai Jogi Bhai Patel versus Union of India and others laid down the grounds of detention must be communicated to the detainee in writing in a language which he understands, and if the grounds are only verbally explained, the constitutional mandate of Article 22(5) is infringed. Here, my lords, our case is that in the arrest memo, it's clearly seen that they have mentioned that I have been communicated the grounds of arrest and my relative has been intimated the grounds of arrest. Both are clearly different, my lord. And the only thing is that there is no written grounds that were furnished to me.
Only writing it is not given to you. That's your point.
Yes, my lords. And there's nothing to indicate that I was in fact communicated the grounds of arrest. They have only written it in the arrest memo, my lords. And my lords, then the next judgments, my lords.
But what is this case?
My lords,
Hari Krishna versus State of Maharashtra. What was the issue involved there? Because the reference has been made as detainee.
Yes, yes.
This is a preventive detention matter?
Yes, my lords. Here the learned court was interpreting the word communicate, that the grounds of arrest has to be communicated. Now the court, while delving into the interpretation of the word
Is
communicate,
it not a different scenario insofar as preventive detention matters are concerned?
my lords,
Because the
here,
procedures are a bit different.
no, my lords. Here in this matter, the learned court was.
There's a mandate that it should be communicated in writing.
Yes, my lord.
Here we are talking about a case under the NDNPS.
My lords, in this particular judgment of Probate Purakasha, the law under challenge was under the UAPA Act and the PMLA Act, where the Honorable Court had reproduced the relevant portions. If my lord peruses the language, it is verbatim as that of section 52 of the NDPS Act, my lord. Therefore, my submission is that the import of those provisions would directly apply to an arrest under the NDPS Act. My lord, may kindly peruse the power of arrest, section 19 of PMLA. It has been reproduced in para 16 at page 21 of the judgment of Probate Purakasha, as well as section 48 capital A, 43B, 43C. And then the learned court observes in para 18 on the next page. If I may kindly read para 18. We find that the provision regarding the communication of the grounds of arrest to a person arrested contained in section 43B of UAPA is verbatim the same as that of section 19(1) of the PMLA. The contention advanced by the learned ASG that there are some variations in the overall provisions contained in section 19 of the PMLA and section 43A and 43B of the UAPA would not have any impact on the statutory mandate requiring the arresting officer to inform the grounds of arrest to the person arrested under section 43B clause 1 of the UAPA at the earliest, because as stated above, the requirement to communicate the grounds of arrest is the same in both statutes. As a matter of fact, both the provisions find their source in the constitutional safeguard provided under Article 22(1) of the Constitution of India. So all of the statutory provisions, my lords, will have to be traced to 22(1). Hence, applying the golden rules of interpretation, the provisions which lay down a very important constitutional safeguard to a person arrested on charges of committing an offense either under the PMLA or under the UAPA have to be uniformly construed and applied. We may note that the modified application of section 167 CRPC is also common to both the statutes. Thus, we have no hesitation in holding that the interpretation of statutory mandate laid down by this court in the case of Pankaj Bansal on the aspect of informing the arrested persons the ground of arrest in writing has to be applied pari passu to a person arrested in a case registered under provisions of the UAPA. If my lords peruses section 52 of the NDPS Act, my lord, that is perimeteria with these provisions of the UAPA and the PMLA.
All right, Mr. Counsel, we'll do one thing. Any other authority you have?
Yes, my lord.
Want to place a lens?
There's one more judgment I would like to put forth, my lord.
What is that?
The judgment of Vihan Kumar.
Vihan Kumar, what is the citation?
My lords, 2025 INSC 162.
Relevant paras?
Para 14, my lords. Para 14, para 16. If I may kindly read the provisions, if my lord permits.
Which provision?
Para 14, my lord. Page number 23 of the judgment.
You'll be reading which paragraphs?
Para 14, para 16, para 21F.
21F.
Yes, then 24, 25, and then there is a concurring judgment of Honorable Mr. Justice M.K. Singh. So, para 2 and 3 of that portion of the judgment, my lords. So, my Lord Justice Singh extends the requirement of providing the grounds of arrest, which is mandated under section 47, also to the relatives of the accused, which is also mandated under 48 of the BNSS. So, merely informing the accused the grounds of arrest is not sufficient. The same courtesy also has to be extended to the relative of the accused. And if even section 48 notice is not supplied, that will also vitiate the arrest. That is the sum and substance of my Lord Justice Singh's judgment. If my lord permits, may I read para 14?
See, what we'll do one thing. These are the two judgments you want to rely upon.
There are two more, my lords.
Two more.
Yes, my lords.
Okay, we'll do one thing. You provide the list of judgments you want to rely upon.
Just two short judgments.
See, I would like to grant him some time to file his objection.
My lords, once we have already shown from the records that it has not been complied with, perhaps nothing further remains on that point, my lord, because they would object on the requirement of section 37. And these are the two exact judgments which are dealing with that
But
point.
the thing is that since, you have to have the opportunity of being given the chance to file an objection. For that sake.
My lord, they have already taken that. That's a reasonable time, I believe, 1 week.
No, I don't think so, because they have, earlier, I think you had pleaded the.
Yes.
So you had to amend the thing by putting the by incorporating the, what do you call, the Enforcement Directorate.
NCB also.
And
NCB.
and on the last time he appeared, took some time. And
Yes, my
perhaps
lord.
today is the second time.
Yes, my lords, that is true, my lords. However, considering also the period of detention, my lord, because the only contention is 47 and 48, and from the records, it's clearly
47,
established.
see, you have seen, this is not the first time it has come. This is first time it came.
Yes.
There's already an order of rejection, correct?
Yes, my
At
lords,
that
but
time,
on the
you have
ground.
never raised this issue.
Yes. My lords, that will not preclude me from taking that grounds, because that's a constitutional rights violation.
Raised.
Yes.
So every time you come up with a new grounds, saying that that was not raised, now I'll raise it.
My lord, but when
So
it
that has
comes
to be-
to a constitutional rights violation, my lord, I will not be precluded from raising that point later on just because a previous
You
council
may
did
not
not
be
raise that
precluded,
point.
but the thing is that you see, I'm just pointing out that that was not raised.
Yes, my lord,
Only
that is there.
point which was raised was regarding your long incarceration. That
Yes.
now,
And my lord,
as on today, how
Yes.
many witnesses have been examined? How many are left?
my lord, to my knowledge, I'll just see. My lord, 5 out of 9. 5 out of 9.
5 out of 9.
Yes, my lords.
Who are remaining?
My lords, the complainant who filed the offense report, the IO, intelligence officer, then 2 seizure witnesses are left, and then the reporting officer of the forensic examination report.
Okay.
They are still left.
Four
Yes,
remaining.
yes, my lords.
And when is the next date?
My lords, that we are not aware, my lords.
Mr. Zoram Chana, do you know the next date?
I'm sorry, my lord, I'm not aware of that one.
This is
What is the objection you want to raise otherwise? You wanted to file an objection.
My lord, that since now they are now relying on that Pankaj and the subsequent judgment, my lord. In that Pankaj,
Vihan.
my lord, Vihan and other also, my lord. They are citing that judgment. In that Pankaj is, if I'm not mistaken, the first one, the earliest one that they are relying on. It was pronounced in, if I'm not mistaken, in the month of October 2023. Now, that judgment, it is specifically stated that this ground to be informed to their arrestee, my lord, the attitude has to be informed, will take effect only after the time of that pronouncement, my lord. It is specifically stated in that judgment itself, my lord. So now,
In which judgment? Which judgment is that?
Pankaj Bansal, my lord. Pankaj Bansal,
On Pankaj.
my lord.
That was the observation.
My lord, yes. Now, since the present case is arrest was made prior to that judgment, my lord. So
What is the citation of Pankaj?
Pankaj, my learned friend have now, I think, already
No, what is referred is Vihan and the Prabir Prokasta.
they all, my lord, derived their judgment.
You have that Pankaj judgment?
no, my lords, but in the subsequent judgments of Vihan Kumar, Pankaj Bansal has been discussed in detail, and then the Honorable Court has formed this opinion in para 14. That's why I wanted to impress upon my lords.
In which case?
Vihan Kumar versus State of Haryana, my lords. I believe a copy has been provided.
Which paragraph?
Para 14, my lords.
40.
1-4.
1-4.
Yes, page 23 of the judgment, my lord. And even, my lords, in Prabir Purakastha, Pankaj Bansal has been discussed, my lord. Both of the judgments are subsequent to Pankaj Bansal, my lord. Perhaps the learned PP has been misinformed on that point. Both the Pankaj Bansal have been discussed elaborately, my lords.
There is also a judgment.
Yes.
Which says that regarding how it should be applied, retrospective or prospective. I think you should find that out.
My lords, even in these particular cases, these arrests were made prior to the rendering of the judgments, my lords. And even those prior cases have been discussed and distinguished.
No, that's what I'm
Therefore,
saying.
now to say that whatever happened before the judgment, no constitutional rights can be protected, that would be an absurd argument in my humble submission.
That's
my
what
lords.
I'm saying. You see,
Yes.
there's a judgment which says that all decisions made in respect of, like in provisions in the criminal law
Yes.
has to apply retrospectively. Not
Yes,
just
retrospectively.
prospectively. There's a judgment. I've come across this judgment.
My lord, in my
Mr. Zoram Chana, I think you should also look into that.
My lord.
If your stand is that arrest happened much before this judgment,
My lord.
that perhaps
I'll
that
do
may
that,
not
my
stand.
lord. I'll do that, my
That
lord.
may not stand.
And that is number one, my lord. And regarding that, my lord, there is one judgment of the Honorable Court, my lord. In the case of Arun Kundongban, also known as Nanao versus CBI, my lord, at para number 24, my lord, it is stated that it would be worthwhile to mention that the Apex Court has held in the case of Pankaj Bansal versus Union of India and others, which is reported in 24/7 SSC 576, that the ground of arrest must be communicated in writing to the accused. However, the case of Pankaj judgment supra can be made applicable only to arrests made after the said decision rendered by the Apex Court on 13/10/2023. In other words, in respect of arrests made after 3/10/2023, an arrestee must not only be made known to the only be made known the grounds of arrest, but the same must also be communicated in writing. Regarding this, my lord, it is stated in that case, my lord, which is bail application number 1100 of 2025, my lord. This is decided by this Honorable Court, my lord.
My lord,
What is the citation? Is it reported?
No, not reported, my lord. 2000. This is the decision made in 2025, my lord. In bail application number 1100, my lord. 1100 of 2025 at paragraph number 24, my lord, by this Honorable Court. So that
All
is
right.
one point, my lord. There is also
all
another
right,
point,
all
my
right.
lord, which I'd like to raise before lordship. So if I
my lord,
time, my lord.
So you filed an objection.
my lord,
I'll
just,
give you some time.
if I may just
My
have
lord.
one indulgence, my lords. My lords, on that point, my lord, I would want to place a judgment of this Honorable Apex Court in Kanishk Sinha versus State of West Bengal, 2025 judgment, my lord.
No, you do.
I'll just read the operative portion, just
No.
just one para, my
See,
lords.
Mr. Counsel,
My lords.
we're not disposing of the case today. That's what I'm saying. We'll fix it. We'll fix the matter on a particular date, and both sides will furnish these citations that you want to rely upon in advance. Okay, a list of citations which you are going to rely upon.
My lord.
When can you file your objection,
I'll file it tomorrow, my
Mr.
lord.
Zoram Chana?
I'll file it
You'll
tomorrow.
file it tomorrow.
My lord.
How will you serve the other side?
I think, if I'm not mistaken, they have the local associate here in Aizawl, my lord.
You have a local.
We have a
counsel
local
there.
council, my lords.
You serve to the local council.
My lord. I'll do that, my lord.
This bench is going to be available in Aizawl.
On the next occasion. Okay.
So I have to trouble you all to one more date.
That's the issue, my lords. The client is not a very, he's not a person of means. Therefore, he has taken great pains for us to.
But you may appear virtually also. It's all up to you. There's no issue.
It's always a pleasure to appear before my lords physically. So we'll make an effort to appear physically as
So
well.
I'd request you all to submit your list of citations
My
in
lords.
advance,
My
so that
lords.
the court can go through that. And I think basically the argument will be on that point only. Mr. Zoram Chana, you also give me your citation.
My lord. I'll do that.
Okay.
My lord.
If it's not reported, you provide a hard copy or at
My
least the date of the judgment and the party's name and all that. That'll be required.
May pray for a short date at least, my
It'll be
lord.
a
That
short
much
date.
accommodation.
Perhaps 15, 17.
My lord, may I suggest 18th?
Right. 18th?
18th, my lords.
Okay. Learned counsel for the petitioner, Mr.
A. Borua.
A. Borua, is physically present, while Mr. Zoram Chana, learned special PP.
See, my lord. See, Zoram Chana.
Sorry?
See.
Mr. C. Zoram Chana, learned special PP. What is this?
NCB, my lord. Narcotic
NCB. Narcotics Control Bureau, NCB, is virtually present. Stop. The learned special PP submits that he has just received the instructions and would like to file the objection, and for which he prays for a week's time. Stop. The learned counsel for the petitioner submits that sufficient time has been granted to the respondent to file their objection, and therefore no further opportunity should be granted and the matter should be heard. Stop. However, considering the fact that the special PP has made his prayer for the second time, court is inclined to grant him a week's time to file his objection. Stop. That the objection be filed on or before 13th of March 2026 with a copy to the opposite party.
Malad.
The matter be now listed. Now, as agreed to by the parties, let the matter be listed on 18th of March 2026. Stop. The rival parties shall submit the authorities they wish to rely upon well in advance. List accordingly.
Obliged, my lord. Give your.
I'm so obliged, my lords, for a patient hearing.